Good morning and welcome. My name is Stan Staters. I'm with the City of San Marcos. I'm on my third year with the City of San Marcos, having retired after 26 years in Avalon. And I think what we'll do is we'll go around the room just to kind of get to know each other. We have a lot of work to do, and I think relationship needs to precede trust and work. So when you give your name, if you would state your preferred name, and I'm going to write that down so that I can refer to you by your preferred name. I would love for us to dispense with titles, if that would be okay with everybody else. Just refer to each other by our God-given names. So, again, Stan.
I'm Jessica. Are we doing an introduction thing? Or I'm Jessica Anderson. I'm Assistant Chief of the Youth Services Department. I know some of you from Austin. I'm also an attorney, so I do some legislative stuff there. I've been with Houston for 23 years, and I'm excited to be here. James?
James Cornell, I'm Dallas Police Association representing it. I'm a Dallas police officer, been on 32 years. Like Jessica, I do the legislative stuff for our association down here, so I've been doing this about 25 years, legislative stuff.
Dennis Ross, Randall County Sheriff's Office, captain of the Professional Standards Division, about 34 years.
My name is Victor Ortiz. I'm the police chief of Metcalf.
My name is TJ Spencer. I'm a patrol lieutenant with the Addison Police Department. I'm also the secretary of TMPA.
Jennifer Szymanski. I'm the director of public affairs for Fleet. Licensed holder for 16 years. Most recently with Austin Police Department for 8 years.
Colleen Grissom. I lead the field services, education services, and credentialing group for TCO.
TJ Vineyard, I'm over the enforcement division with TCO.
Gretchen Grigsby, I'm the government relations director for TCO. As I've seen many of you over the last few months, this is important work to all of us, and thank you for being here.
John Beecham, I'm the interim executive director and general counsel for TCO. Thank you all for being here. Look forward to serving you and helping you any way we can as we move forward, as we work together to do the work on this thing. Thank y'all so much for being here. Appreciate it.
Jessica Caparro, I'm the Chief Information Officer for TCO. I'm over IT and Special Services, which includes background, confirmations, agency creation, and a whole slew of other things. But I've worked with the TCLED system for about 12 years, and I'm looking forward to implementing the means to make our new sunset processes happen.
Aaron Heath, I'm an assistant general counsel, legal division, TCO.
Iris Martinez, the legal assistant here at TCO, and I'm also the advisory clerk for
Jason Moore, I'm chief deputy with the Constable Office, Walker County Precinct 3, about 25-ish on the state and local level.
Christy Lewis, I'm the HR director for the city of Tomball.
Carlos Garcia, I'm the DA for the 79th Judicial District. That's Jim Wells in Brooks County, down in South Texas.
Cliff Drake, I've been with DPS for 14 years. I work inside the recruiting division.
Jim Devlin, I'm the assistant city manager for the city of Houston. Prior to that, I was the chief of police for 11 and a half years. Been licensed for almost 30.
Do we need to identify others in the room?
Sure. Got TCO staff in the back. Go ahead, Sarah.
Good morning. I'm Sarah Flott. I'm the legislative coordinator for TCO in the government relations division.
Sarah Beth Barksdale. I am our PIA coordinator for TCO.
John DeVega, I just work under Jessica in the IT department.
Phyllis Polo, legal secretary.
Shelley Knight, accounting.
Brian Roth, chief financial officer at TCO. I want to echo my colleagues' sentiment. Thank you for being here. There's many other things you could be doing, but you're here with us. Thank you. We appreciate it.
I'm Dan Morales. I'm sergeant with E4.
Well, I know this will be unorthodox, and I don't think the other committees will start off with this question, but I'm going to, and it will serve a purpose. Tell me what is found on the common United States penny. Don't take one out, and don't consult Google, who knows all things. What is found on the common United States penny? Go.
Abraham
Abraham Lincoln, good, let's start there. Is he looking at you, is he looking right, or is he looking left?
Right.
It isn't common penny, is he looking left or is he looking right?
He's looking to the left.
Yes.
The left side of the coin, yes.
He is looking left, so you see his right profile. What is on the penny? E pluribus unum, which means? Out of many, one. Out of many states came one nation. What's on the penny?
In God we trust.
In God we trust. It has lots of features.
The year, the same.
The year, keep going.
It says 1 cent.
The value, everybody forgets the value. Keep going.
It's like where it was minted.
Mint mark, right. What's on the back?
Just like that. Lincoln Memorial.
Memorial. A lot of people say it's a memorial. They don't know who. Well, Abraham Lincoln's on the front. It's probably his memorial. It is the Lincoln Memorial. There's a word. It's foundational to your country. I could buy you a consonant. L.
Liberty.
Liberty is on the coin. What's it made of?
Copper.
They were copper. They'd break into your cars to steal your pennies. It is zinc. 97.5% zinc, 2.5% copper. So it's an alloy, but mostly zinc. Is it smooth or is it bubble? It has a lip, but you say smooth? It is smooth. What does the penny have to do with this advisory committee?
Everybody do something, nobody do all.
Bingo. Or, this is what you're gonna get paid, a penny.
We're all here to give our 2 cents.
And for a penny and for a pound.
Yes. The penny is really a good frame of reference in the fact that when we think of things, we struggle as an individual to define the attributes of a system. But collectively, what did we do? We came up with literally every attribute with a little bit of help on liberty, which I normally have help with. And so it's in that vein that we also approach this task before us. Courtesy of John, we have sent you a lot of information so that you kind of understand what we're doing. I suspect there's going to be a lot of great discussion because this is a very difficult topic or topics. I also believe, I could be wrong, that you're here voluntarily. You wanted to serve on a TCOL committee, and it's my belief that most of us received our first selection. So for whatever crazy reason, I suspect it's because you want to uphold our chosen profession. You chose Officer Misconduct and Personnel Affairs. So I'm personally excited to work with you. If anybody should be able to walk into the room after this first hour, they should have no clue who's the boss in here. We should have free-flowing conversation, and everybody has good ideas. We have a couple of parliamentary procedures to contemplate. Do we want to use Robert's rules? If not, do we want to just try to navigate this without Robert's rules? That's a question I pose to the group.
Yeah, I don't think it's necessary to use Robert's rules.
Okay. Any dissent? So we are going to have organic conversation. What could possibly go wrong? So TJ, you're with Addison?
Yes, sir.
As well as TMT?
Correct.
Which I assume is an elected position.
Yes, sir. That's correct.
And you're with Austin still?
I'm not.
You're
No,
not.
I'm a
Now you're
reserve.
full-time fleet?
I am full-time fleet. I do still hold a license as a reserve with the county.
When did you leave APD?
2019, just in the nick of time. Sorry, really.
All right. So, John, Gretchen, if I go awry, correct course, please. Item number 2 on the agenda is discuss and take action on advisory committee procedural and preliminary matters if necessary. We have agreed that we're not going to follow Robert's rules. We'll do it more organically. Is there anything else that we want to contemplate as it relates to procedure? All right, item 3 is basically the wheelhouse for why we're here, discuss and take action on matters related to developing model policies establishing procedures applicable to a law enforcement agency, investigating alleged misconduct by a license holder employed by the agency, and hiring a license holder, and regarding personnel files maintained with respect to a license holder as established under Texas Occupations Code 1701.4522 and .4535. And so I suspect that is where we'll spend all of this day. So I think we need to probably begin with a review of literature. John, can you lead us in the review of literature of what's been provided?
Sure. I'd like to have us start off with an overview of the advisory committees, the general hiring and misconduct process, and work through the draft of this. This is the general overview, and then we'll go into the documents that you all have before you, the first draft of the misconduct process. Again, as we go through this, we'll probably be making some changes to it, obviously, but this is just to give everybody a good idea of where we can start and where y'all's discussion can begin. So, with that being said, let me grab the pointer here. And as always, Stan said, TCO staff, jump in at any time as we go through this and we discuss it. Okay, the 50,000-foot view of advisory boards in general, of which you are one of the three, we have, I'll go to the bottom of the examination of a licensee that relates to medical and psychological exams. They'll be meeting tomorrow. The minimum standards for law enforcement agencies, as you see in the white box there, they met yesterday. And of course, here we are in the rose box, the hiring, personnel files, and misconduct committee. All these, of course, are from Senate Bill 1445, the TCO Sunset Bill. Now, as Stan's read off the charge related to misconduct, policies, personnel files, and misconduct, we also have two databases that were a result of the SB 1445. We'll talk about this one first and get into more of the immediate and specific one before us today, that ultimately everything that we're going to be talking about ends up in, as Jessica was referring to earlier, this will be the ultimate means to which you all accomplish your mission as it relates to hiring and misconduct. But until then, we have the officer service reports. This is the public database with outwardly facing information that will be on the TCO website showing officer information. Again, this is the public database that TCO has been directed to create, establish a rule, and create by September 1st, 2024. And of course, where we're at, the hiring database, the confidential database for, and these we'll adjust the names on this. This is a note to myself and staff. This section should read personnel files, and this one we'll just park the name to have a name for TCO files. But for the purposes of the concept, they're where they're supposed to be. These are the files that are either the personnel files from the agency created under 4522, 4535, or already in existence under Local Government Code 143.089. And these are the out-of-state post records, which agencies will review, which will be the responsibility of TCO to put in the database. And we also have here the designated decertification database. And again, the policies and procedures related to this is the charge of this committee are due by March 1st, 2024, the model policies submitted to the commission. Does anybody have any questions on the general overview of this committee and the other subcommittees, or excuse me, other committees and the databases as a big starting point? Any thoughts, questions, or comments?
So the databases that you've got under what's the personnel file, when we talk about this, the big question comes up, what is releasable? My officers are always concerned, what is going to fall under open records? What is going to remain confidential to them in regards to the files issued by my department that send down here? Okay, are those going to be confidential? Because they may be in my department, and then you may be releasing it. Where are we going to end up on that? Because that's a critical...
It's a critical question, and we got a response for it. if we want to hold on to that just for a minute as we go through the misconduct process, because we have to remember two things when we talk about confidentiality. As it is to the public and as it is to other hiring agencies down the road. And we will certainly make that distinction, and that's a great discussion we're going to have, and thanks for bringing up it already.
Okay.
So we're already thinking about it. That's fantastic. Ultimately, all of this is going to end up in the confidential database, what another department gets. But then we'll get into what the public can get and what the public can't get, but that's different than what other agencies or in the hiring process can
Right,
get.
I would expect.
And
Absolutely.
from where and all of that.
That's right.
Right.
We'll get there.
John, quick follow-up.
Sure.
Contextually, what transpired in the 88th legislature that really led to the promulgation of this Senate bill and us even being here? Kind of give us the context.
Sure. I'll give the generalities, and Gretchen can probably give you some more specifics. But this is a continuation back to the previous legislative session of SB 24. Senator Huffman from Houston created the secure share system for here at TCOL to be the conduit to have broader, more expansive ability of agencies in their hiring decisions. Where in the past, as you all know that were involved with it, it was a matter of inspection of records, who sent you records, who didn't send you records. It was kind of a quilt approach to it. SB 24, the predecessor to this, created the system for TCOL, to electronic system for all agencies, no matter where you are in the state, no matter what size you are, to have the ability to see in a confidential matter all of the records from a previous law enforcement agency in making a law enforcement decision to hire an applicant, or in most cases, even more importantly, to not hire an applicant based on that information. SB 24, what we have in SB 1445 is both a continuation and an expansion of SB 24. Gretchen, do you have any thoughts about, or add some color to what I just said?
Absolutely. So, again, as John described, Senate Bill 24 created the TCOL secure share system, laying out the method by which agencies could and shall transmit background documents, right? So you're hiring an agency, you go into the TCOL secure share system, unless you mutually agree that you go through those records in person, and those get transmitted, those get reviewed. We've got records of, who's doing the reviewing, how long they're spending on those documents, everything like that, and then a background confirmation form is submitted. So that created the how. Senate Bill 1445, the sunset bill, adds on to that and creates the what, right? So in 1701, there was not a previous definition, if you will, of a personnel file and what did or did not need to be included in that. And that's where this bill comes into play from our view for the purposes of this committee, right? It includes the what gets transmitted. And many of you were involved in those discussions very deeply, and so there are some obviously finer nuances that we'll be working out here as a committee, but that's the broad view of it.
So Senate Bill 24 was the 87.
Yes.
Yes. And then 1445 is the 88, attached to the what is to be included.
Yes.
And then 1445 also necessitated the 3 committees.
Sure. Yeah, and to your point, it does many other things, but for what we're talking about today, that's kind of the narrow view of it.
And Jessica, if you could, from the technological side of it at TCOL, explain TSS to maybe some of the committee members who haven't had interaction with or exposure to it.
SB 24 kind of laid out 2 technical components. One is the actual facilitation of sharing documents, which is what we call TCOL Secure Share, or TSS. And so that background investigator can go to this system, make a request for documents to former departments. So they'll make several different requests depending on how many departments the individual has worked for. And the responding department will upload the files, and then the background investigator has a certain amount of time to view those files. At this time, those files are transitory. We're not keeping them. They just live for the purpose of the transaction. The second component of that is the background confirmation form that departments have to fill out saying they contacted this list of departments and they either used TSS to view the documents, or they went in person to view the documents, or there was an absolute refusal to share documents. And then they send that form to us before we process the appointment of the individual.
The statute said that an agency can't refuse.
There had to be.
We had to have a way to collect that information if that was going to be the case, because there is a specification that it is subject to the suspension of the chief administrator's peace officer license if they refuse to comply.
So if I understand correctly, it was discretionary. They could either do the TSS or go directly to the agency, but regardless, they had to provide a confirmation that they did one or the other.
Correct.
We didn't want appointments to be held up if they could not get the file from another agency, so we create that alternative. Those get referred to enforcement. We follow up to find out why the files weren't provided. And then there's some other, for example, if it's been more than 2 years that the files no longer exist, there is a way for them to mark that as well. So there's a few outside possibilities that they report on that form. We just need to see that they made a legitimate attempt to view them, to obtain and review the files as required by law.
And now you are going to take all of that initial effort and say, well, wait a minute, we're now going to become a repository. And everybody will go through TSS and then confirm.
The TSS part is one of the things that we're going to have to work out is, does that continue to be the method? But ultimately, yes, we will become a repository for this information.
So if you have an agency or chief administrator that just absolutely just says, I'm not showing you the file, what's the recourse there?
I assign an investigator, we open an enforcement case. Most of them, we find out that there's questions about how Chapter 143 applies early on. That was we've had agencies that didn't want to send internal affairs files to human resources, and human resources sent it through, so we found ways to do that. We have not had an agency that simply refuses to share files yet.
I got one for you, I'll do it.
Okay, and we can work at that. In the end, they harm the licensee, right? Because the licensee can't get a job because the new employer needs to review those files. And I think that's one of the things that's going to be interesting to discuss. We have an agency already refusing to release a non-sustained complaint, but it's a shooting that an officer was involved in. He was cleared of any wrongdoing. Another agency wants to hire him, but because the grand jury just took no action rather than billing him, the other agency wants to see that file. So they're kind of boxed in, and I think it was anybody's intention to create that problem, but right now, because it's undefined, that's a problem. That's the examples that we'll be able to provide as some of the challenges we're seeing with how people are trying to comply with the law, but creating barriers for other agencies. I think all of it's unintentional.
I got a question, follow up on this one right here. His agency's confidential, you're confidential, the agency that's inquiring may not hire him. How does that stay confidential in that file?
As far as what they've reviewed,
Right.
that's still in the confidential database.
No, I understand that, but how does that get protected in that third agency's file?
The way,
And
go ahead.
supposing he doesn't get hired, the officer doesn't, he or she doesn't get hired. We got background information with references to whatever they got from you, from that agency that was confidential.
That's a good question, because here's the thing, if you're saying if they're not if they have possession of these type records outside the confidential database, what happens to the confidentiality of those records? And this gets back to the question we're going to have to solve, because nowhere in the statute does it provide for confidentiality of some of these records, and we'll get to that slide in a minute. I'll just go to it now.
And I know it's early in this process, but
Sure.
But there's some, open records.
Absolutely.
Implications, for that third agency.
Absolutely.
So that, and I don't mean to necessarily solve it right now. I just
Sure.
want a piece of information maybe we could explore that.
Absolutely. Let's keep that in mind, because that's a good question, and that's got some sophistication to kind of what we planned for in the initial phases, but I think I've got a short answer for you that will respond to both of these at the same time in just a second as we go through this though. The short answer is it depends in whose hands it is, but for the most part, it's going to be confidential. That's what I can give you right now. Okay, I'm gonna bounce back to this, and we're going to be focusing on this part of this from the big picture and go to our draft misconduct investigations flow chart. Again, this is focusing on the misconduct. The hiring and personnel part is separate and apart for right now. Okay, what are the agency's requirements under SB 1445? As you see in this document, you'll have all the citations to the particular statutes and provisions of SB 1445, and also you have a comparison chart with civil service 143089 of the local government code, the personnel files for everyone else under 4535 and 1701, and the general procedures under 4522. You'll have that in your materials, but we'll walk through this. Agencies required to initiate an investigation into quote-unquote alleged misconduct. If the officer is employed and the agency becomes aware of the alleged misconduct, and they must complete the investigation in a timely manner. You see this right there. We'll get into when and what needs to go to who in a minute. What does misconduct mean? It's defined in 1701-001. It's a violation of law, violation of an agency policy, which the agency can suspend, demote, or terminate the license holder's employment, or an allegation of untruthfulness against a license holder. Again, that's the defined misconduct that an investigation must be initiated into under the statute.
Can we camp there for just a second?
Sure.
So when I read that, I'm curious from you all who were actually working with our representatives, how did we allow an allegation to become reportable? I mean, this is a pretty big departure versus it's sustained. There's been some level of investigation. Now it's just simply an allegation. What was the backward?
We didn't like it.
Yeah.
An allegation, that's all it is. Now, it does go to the state, part of us is named, but Jennifer didn't, yeah.
We lost.
We lost.
We're outnumbered.
They just put it, did it.
So,
But also we had, the understanding that this was going to be also worked on in this committee, and that there were going to be potential rule changes or model policies that shall be adopted. That would give some discretion to this committee to further define that or place other measures in there that would protect, allegations as opposed to sustained untruthfulness.
So John, some history on 89G was designed exactly to protect officers from somebody effectively constructing a record of misconduct. It seems that it goes out the window with this.
It still remains. Let me jump to that. Let's say you have your alleged misconduct, the investigation occurs, the investigation is completed, whatever due process within the agency occurs under 143089 or other department due process that exists. This goes back to y'all's questions about what's confidential and what's not. And keep in mind, we're at the agency level right here. At the agency level, as it exists, let's do the most simple Public Information Act request. You still have, for sustained allegations or misconduct or everything that goes into 143089A, it stays the same. It's the same misconduct, evaluations, the honors, awards, everything that goes in there, that's still the same and is subject to disclosure. 4535 of the Sunset Bill creates the same thing for, I think you can make the argument for non-civil service cities. You still have the same thing to capture those files, and specifically, narrowly under what we're talking about now, sustained misconduct goes in there, and that green box is subject to disclosure, okay? As it exists now. What doesn't change is if it's unsustained, and we go into the, under 143.089G, the quote-unquote department file, or the agency file, or whatever you want to call it, everything that's not in the personnel file, that remains confidential. It all remains the same. The confidentiality under your G file at the agency level in response to a Public Information Act request stays the same. That information is still protected. Now, this is what I was talking about earlier. If you're not in a civil service city, this is what I think is unclear about the statute, but I think there is a solution, at least till the next legislative session. If you're not in a civil service city and you don't have a technical 143.089G file, because that's the only, in our side-by-side analysis of the Sunset Bill and civil service law, in our analysis, that's the only thing that's missing is a complementary G file to the 4535, 4522 file. Does anybody have any questions about that? But I think there's a solution there that we have to think about, or at least proposition to think about.
So, again, I understand that, but right now, pursuant to the last legislative session, even G file material now gets transmitted or is exposed to you for some applicants, agencies review.
That's correct.
And we go back to the question I had before, which is again, what if that agency doesn't hire him? Now that agency has or two or three agencies that may have inquired, have a background of sorts that reflects the information that would have been absolutely protected. So again, I don't know, I don't think we're gonna solve this here just this minute.
Sure.
But I wanted to go back to the top part of that slide, if you don't mind.
Sure. I'm gonna roll up and you tell me when.
Yes, sir, just to the pink section.
You got it.
So, I understand misconduct. It was defined in the bill this time for us.
Yes, sir.
I don't necessarily agree with it, the way it's defined, but nonetheless, that's what it is. And what I'm going to suggest to you is that unfortunately over the years, we've tried a whole series of things, the F5 being one of them. You know, I mean, finally it got thrown out this time around, but the F5 was thrown, and it forced many agencies. Every time we did something like this, it forced many agencies to find carver remedies. Okay? So, what I'm suggesting to you, and this is what's dangerous, is when we have may suspend, you know, who is the judge of may suspend, fire, or otherwise? And I understand, we're gonna try to come up with a model policy. I'm just telling you, what I'm hoping that we can avoid is some of the repeat stuff we've done over the years, and forcing people and agencies into the shadows again because of this, or using this as the vehicle for that, in order to preserve some of the things that we're discussing right now. It's just food for thought.
I think those are great points, and I think when you talk about may suspend right there, I think that's something certainly that this committee can look at and see if there can be firmer guidance within that word may. I know it's discretionary, but it's also a sliding scale. May means what? I mean, to what extent is it just...
What if I choose to just
right.
do a written reprimand for having committed some act that, you know, because of the language, I'm just going to reprimand you and not have it exposed. So again, I'm just saying, over the years of trying to do some of these fixes, we have pushed agencies and people and personnel. We're not even mentioning collective bargaining at this point in time. Some of the agreements that can take place, number one, or any civil kind of action or enforcement that could take place because of a civil resolution, so to speak, in an individual personnel matter. we're not even going there yet, but what I'm saying, I'm just making a comment here is over the years, we have done things that have pushed us around, and we just complicated our problems every time. And I'm afraid here with that language, unless we do a really tight job on this, we're gonna be doing the same, if not worse.
No, understood.
To his point, the may is problematic, I agree with him. 143.052 says that if you suspend, demote, indefinitely suspend, or if it's criminal, then it's absolutely a file. So if we have discretion with the may, that's an easy fix. We don't change. We don't allow it, because I agree with Victor, we don't allow it to become the de facto G file. We stick with, it has to warrant a suspension, demotion. You actually have to have done that to remain A. I think all of us would agree with that, wouldn't we? I want to go back to you started a really good point. There is no corresponding G file for counties, and we have counties represented, so we need to really unpack that a little bit more.
Absolutely.
So can you finish that thought with
Love to.
county?
Let me scroll down first. And I'll just say everyone who's not currently under 143.089. Again, the problem with confidentiality in Texas is it has to be expressly confidential to be confidential. We can't, as T-Code, make something confidential by rule. You as a committee can't make it confidential by policy. It has to be the legislature saying something is explicitly confidential. And as said earlier, this, both in case law and statute, the G file is confidential. Now, I have some thoughts, and it's something for you all to think about. And staff, we've come up with it. I think if we look at it, we don't have a confidentiality provision for the corresponding G file for everybody else. The unsustained misconduct that we know protects the rights of the licensee. As we know, all the G file case law says that stuff should be protected. We know that this ultimately goes in a confidential database where it's protected with respect to the world again. So, how do we get this to be as protected as the G file and before it gets to the confidential database? Because once it's in T-Cole's hands, we know it's protected there. The problem is it's still sitting in the agency file before it goes to T-Cole. What do you do with respect to confidentiality there? I have a proposal, and it's something to think about, and it's something to kind of meditate on as we go through this process. I think that you can reasonably rely on legislative intent, both in SB 1445, confidentiality that's given to G files and case law, the confidentiality provisions that's given everywhere else other than when it's in the unsustained allegations file for a non-civil service entity. I think you can designate for submission to T-Cole, designate for submission to T-Cole's confidential database based on several provisions there. It's something we could come up with our own end for y'all's review, and you could claim confidentiality on that information until it gets in the confidential database. So, without a corresponding confidentiality provision, I'm saying that you can attempt to keep it confidential by saying it's designated for further transmittal into the confidential database of T-Cole. And this would be something on, you have in front of you, this kind of goes hand in hand with what some of the forms you were handed this morning, the initial misconduct / all other investigations form. That's something that you could put on that form, designate it, and that way you could at least claim in response to a Public Information Act request that this information is confidential. And that's kind of the best solution, that I can see right now until we have it expressly, to either get some case law that says it's confidential or go back to the legislature and say, hey, there's a hole there that's got to be fixed because there's not a provision right now saying it's confidential.
What do these non-civil service agencies do now? So, Jason, I assume.
It's a good question.
Yes, they release it.
So we're making an issue that's not even an issue, really, are we? Because they're already releasing it, so.
I think you could claim, there's some privacy claims you could make and some other claims that you could make. They're theoretical, if you want to withhold that information. But I think the legislature, what they really intended to do was make this stuff confidentiality. They just forgot to do it.
And
Or,
again, I think it's important that we draw the distinction between confidential to the world and
Yes.
confidential to a hiring agency.
Sure.
yes, again, this
To
is,
Victor's point, that can become blurred when it's 3 agencies down the road, and somebody does a PIA request and says, hey, we understand this person applied for you, we're asking for that document. Whose document is it now?
but that's where I'm going back to designated as for submission into the T-Code confidential database, you use that as a claim of confidentiality.
So the third agency would.
Yes, or the agency who holds the records, or that if any agency down the line who have gotten this information.
So John, the other thing that's different here today is that previous to now, it was on a request basis. Now we're saying, based upon this, that we're reporting all that fits within the definition that's been put forward in 1445. And that's the form you put here in the model form. Now we're reporting all, which, again, now that, because of that, this elevates its importance. What we had the last two years ago, where you're saying, if you have a G file and whatever else, and somebody's applying for it, you gotta show it, okay, we're living with that right now.
Yeah.
This changes all of it.
You have to have something in that right now. Where in the past, you're exactly correct, and then your question was, some of them aren't, some may not have anything that would go in this spot now because they haven't had that standard to create investigations in response to alleged misconduct.
What is T-Cole doing with PIAs? Nothing? Ignore them?
We don't know. We're not going to get these requests here. We're not going to get these requests.
No, I'm saying, once it's in the confidential database and somebody requests my records, they do a PIA with T-Cole asking for what's in the confidential. What are you doing with that PIA?
They're sending it to the Attorney General's office and saying, we're withholding this information under 1701, 168, it's all confidential. Cite the statute, and that's it.
If somebody wants to get it, it's gotta be from the agency.
Okay, that's where it was.
This is, once it comes to T-Code, either in the form of these two during the hiring process, which, leaving that aside for now, just focusing on the misconduct. Once you go through the process internally and you send T-Code, hey, either criminal charges were filed or there was another investigation, what the result was, and that goes into here, no one can get it.
So to Victor's point, if we contemplate some type of form letter that before you share from the confidential database, there's a form letter that says this information is being shared with you confidentially. It does not trigger a PIA request. These are not your records to release in response to a PIA. Can we do something like that?
I could see that.
And would the AG agree with that?
That's why I'm going back to the beginning. That's
We would need an opinion from them.
That's right. That's what I'm saying. There's no specific confidentiality provision for this until it gets into here, either in the hiring process or one of these misconduct reports. So that's what I'm saying is there is no express confidentiality provision. So we're going to have to send it to the AG. Somebody is going to have to send it to the AG's office, and somebody's going to have to get an opinion on it, and it goes from there. Or, I mean, frankly speaking, go back to the legislature and say this is lacking an express confidentiality provision. Then we can talk with TJ. He had a question.
Well, we're going kind of fast. The way this is supposed to work, they should not be taking custody of those records at any point. They should be viewing those files, making notes from those files. They shouldn't be downloaded. They shouldn't be printing them. They shouldn't have physical custody of the records to begin with. I think what the chief's concern is when you write a background report and you refer to the unsustained allegations in your background report, that now that background report is subject to public information request. But both problems should be contemplated and addressed by this committee because we don't have a way to physically prevent them from downloading or saving those files, right? You tell them they're not supposed to, do warn they're not supposed to. There's a question of whether or not we can do that on a software basis or whether that should be part of the policy. I think it should be part of the policy in how you conduct a background investigation. You never physically take custody of another agency's files. You obtain them, you review them, and then you're done. That's the way TSS was intended to be used, right, Jessica? Was to allow you access to view them, but not to take custody of the record. You can't produce something you don't have. Now, your issue is once you put in your report, right after reviewing those files, if that becomes public, and that's a separate issue.
You're not releasing records, you're releasing the personal history you conducted, report, so to speak.
Yes.
That makes reference to something that's confidential, which in that process can get disclosed. I wanted to make just 2 more points on this, and I don't want to get stuck on this, but you know, all this is all good in terms of confidential stuff and all that other stuff, but when you get hit with a lawsuit and you get compelled to produce in a courtroom, that changes all of the rules.
Oh, yeah, if you get subpoenaed, you gotta give it up.
So again, I go back to who has what, but nonetheless, you know, the objective of the exercise that led to this, as far as I can tell, based on my interactions with the Sunset staff, was to address the, so to speak, gypsy cops kind of stuff that goes on. You know, people that move around from one agency to an agency, they didn't cut it here, we'd rather they resign rather than do something, and then they go on to somebody else. That's what they were trying to address. You know, maybe I'm oversimplifying it, but maybe we ought to, in that process, keep that in mind, and maybe that's what the most direct way to try to do some of this stuff, although we're still saddled with 1445. And we have to do the things that 1445 asks us to do. But if we keep in mind what the objective was, and that was, how do we address people moving from one agency to the other, basically, without their record to some extent.
And to clarify even further, I think what we, in our discussions, it's just to allow chief administrators to make fully informed decisions before they hire someone, right? That they can review and evaluate that. They can review the 20 unsustained complaints. They can evaluate that, still hire that person. Part of the problem that they're addressing at the top, and that is attached to the whole idea of the officers moving around, is that there's still a lot of agencies that allow people to resign under serious allegations of misconduct with no investigation and no documentation whatsoever. And that is, I've talked to people who were under investigation by federal officers, custodial interrogation, 2 months later they're appointed with another agency that claims they knew nothing about it. That problem has to be resolved, and I think that's what's contemplated at the beginning of that.
And you'll see end result of that where if you have an administrative investigation, after it goes through the internal process, that gets submitted to TCOL, proof and a summary of that internal, let's say an admin investigation that resulted in the termination of an employee, it's got to be within 30 days after separation of the licensee or sooner, or strike that 30 days within separation of the licensee. If it's I would guess a termination event is what that particular provision covers. That effectively acts as the conditions surrounding the separation, replacing the F5. That particular piece of it does.
And to TJ's point, now the law stipulates you shall complete the investigation, not discretionary.
Correct. You can't leave it open
You
or
have to
say.
investigate. They didn't even, it's not they didn't finish it. They never investigated it.
That's right.
Well, now you have to.
You have to.
And you have to do the report.
So you should not be able to hire somebody and not know about something that occurred.
That was one of the reasons too, going back to your original question about how is that allowed to stay in SB 1445, was there was a thought too amongst some of us that there at the at-will agencies, there were no investigations being conducted. And so in a way, a lot of our members, would actually benefit from some investigation so that the next agency can see that investigation. Because at at-will agencies, it just wasn't being conducted. And so prospective agencies were hesitant, obviously, because we had the checkbox dishonorable. And even if we don't have that, like we don't now, they still want to know why someone was terminated. And that's still going to be a factor as to whether or not they get hired. So if there's something in that investigation that can assist, which we've found with our members in many cases, there is information in there that can assist, or there's something that's unclear and they should be afforded the opportunity for future employment. So that was kind of a part of that.
So that is what I'm saying, is it's going to push us back in the shadows again and do some stuff, because if I'm going to be required to complete something, when I don't have access to the party that's the subject of the investigation anymore, I'm gonna say I completed, I can't reach a conclusion. And so here you're gonna get it, and again, I'm not saying I'm doing it, but I'm just saying, that's what this does is when we're forcing it down this way, is we're aggravating our problems rather than resolving them. Because if I'm gonna be made to now, you got by law, you got 30 days, after 30 days of separation, you gotta complete it and tell us what you did. I'm gonna tell you, how do I investigate somebody that's no longer accessible to me? Because he resigned.
And how can you make a conclusion?
And how do you make a conclusion on it?
You can't, because then you're just throwing your own your ideas. The chief says, okay, well, he's not here anymore. I guess, I'll just put it on this.
Right. And so that's what I'm saying about, sometimes we push ourselves into the shadows more so than, so again, I'm just a commentary, that's all I'm saying is, we've gotta be really careful if we're gonna try to maximize the effect of the task before us. We can go down the path, but I guarantee you that's what's gonna happen. We're gonna push more into the woods as opposed to bringing them out in the clear.
No, understood. I think the points that y'all brought up about access to direct personal knowledge of to persons or evidence or whatever the case is, to come up with a competent, accurate, complete investigation upon separation, I think that's something certainly within the discretionary policy power of this committee to see if there's some way to ensure that final administrative report is accurate and has some basis in personal knowledge and everything that y'all discussed.
Well, would it be acceptable to say at the end, no conclusion made?
Sure.
At the end of the day, you're requiring a conclusion. No conclusion can be found. If the chief or whoever's doing this, the sheriff just says, because the person left and is gone, not cooperative, you don't have any witnesses, whatever.
Sure.
Is it acceptable for the admin to say no conclusion can be reached? Is that a conclusion?
Which is a hybrid of the F5 system we were using, and I said he resigned, as opposed to he left because DEA is coming after him, next month or 6 months from now, whatever. Again, I'm just saying, this is, we're kind of rehashing this stuff. If I have that option of saying no conclusion, I'm just saying it's just a different version of what we were doing before.
But all of these have value in understanding the next chief, if he knows that guy refused to cooperate with the investigation, refused to be interviewed, that he can consider that. If at some point you're documenting as opposed to just was not investigated and there's no documentation, that's the problem we have now. And I think it's important to maintain perspective. We all get caught up in catching bad guys, right? We forget that that's such a small portion of the population. It's the same with law enforcement. We're talking about 1 or 2% of the agencies. I deal with them over and over. It's the same ones. They're not failing in one area. They're failing in all areas. This is one of the areas that's drawing attention, but they're failing in multiple areas. So these are the outliers. The policies you write, the processes you create, all the agencies that are here are following the ones that exist, and they will produce a better product that will make other chief administrators, it will make it easier for them to make hiring decisions. When we focus on the loopholes and the people who are going to use the system, it's a very small group, and we do need to plan as much as we can for that, and understand that I am finding failures in multiple. They're not doing the BCS right, they're not doing the hiring process right, they're not writing background reports, they're failing in all those other areas.
I don't disagree, but yet as small as that is, we're here because of that.
And you may create tools, though, if our rules require them to follow the policies on the investigation, and the example you give, if they don't try, if they never contact them, they never try to do an interview, they don't try to do an investigation, if you have some mechanism to compel them to do that, then that's better than where we are.
But it doesn't prevent an agency from hiring. We've got a guy in Texas who's worked for 33 departments.
There's a couple of more.
Yeah, but I mean,
I understand.
So they bounce around. So when we talk about that, this Jennifer Carter, she had the number. There's such a small amount of these gypsy cops, we call them, that it's ridiculous, and you can't prevent them.
But those chief administrators relied on the excuse that they didn't know, or they didn't know these things. That excuse has been taken away. Now I'm finding where they're not following the process, where they're not following the requirements of 1701, 451, where they're suspending people's licenses, or chief administrator's licenses. There is a mechanism. It's better than what we had before, where they called somebody on the phone and asked, would you rehire them, and they said yes or no, and that was the entirety of their background investigation with that agency.
So just,
All of this would build up to
just like there are bad cops that we're trying to address here, there are also bad chiefs. So we can't, I mean, we're not gonna cleanse the system with just this right now. So we may have the best system in the world, and we still have bad chiefs making, you know what, I'm still gonna hire you, or whatever it's worth. So you're gonna have some of those. It doesn't fit in here, but I'll mention it anyway, especially in today's time. All of us have a very difficult time getting people that want to do this work. I just say that as we go forward, that we don't make it more difficult for those agencies to find people to do the work. So, you know, again, that's a very small backdrop to the task at hand, but I think it's worthy of mention, because if I say to you here that, you know, how big is your problem about hiring right now? Every one of us have a degree of it right now, as opposed to I'm the only one that has a hiring problem. So I just kind of wanted to pass that along as we go forward.
Just to offer a counterpoint, I think we would all agree that we want the right people for the position. So I wrote down an action item just to move the discussion so we can collaborate. Contemplate incomplete investigation due to employee separation and or death. So we'll contemplate that when we do the policy. Because I think it's hyperbole to say that you can't always complete the investigation. Many times you can complete the investigation. You just may not have the motive. So we can contemplate reasons in the policy for sometimes when you can't. Any other items that we need to consider? Will we take a break?
I wanted to say one thing real quick. On the G file, one of the issues that we're having, and I'm wondering how much leeway we are going to have in here when it comes to confidentiality and really just confidentiality in the two different sections. If they're, we've requested an opinion currently, or a reconsideration, where the AG basically is saying that, so this new statute says that you shall, I guess once we adopt the model policy, it's going to say that you shall maintain the file. 089G currently says you may maintain the file, so this has come up recently.
How about the department file may maintain now under 4535 is must?
Now you must, which is
Right.
great if we're going to be able to encapsulate that here, and it's going to be allowed. I'm assuming it's allowed now because this statute passed. Does that mean that we are also allowed to do something in section 2 that talks about, you know, may information contained in a license holder's personnel file may not be released without their written permission?
On that point, let me ask, did 174 get trumped or not? By this?
174, I'm sorry.
The clearly provides that 174, any collective or bargaining agreement that comes out of that supersedes anybody of law, unless,
That's a good question. I mean, with relation to, are you?
That's the G file.
Yeah, so that's our question right now at hand with the Attorney General's office, except we're not asking about 174.
Right.
We're asking about 143, which should be the same question to the Attorney General's, is can meet and confer contract, or a city ordinance in this case, can it, and this goes to your point, Chief, about if for some reason they're no longer required to maintain the file, then what happens to all of those things that we're talking about, like written reprimands, oral counseling, you know, all of those things that, where do they go? Do they shred them? What's allowed? If they're not allowed to keep them, or if they have a choice, whether or not they keep the file. And again, if they, it really will, I agree with the Chief, it will make discipline look completely different in law enforcement, because they're gonna be hesitant to do certain things based on what's confidential and what's not, and it shouldn't be that way. We should be able to discipline through written reprimands, whatever way we want, whatever way the supervisor see fit.
Yeah.
And shouldn't have to worry about, oh, I want to do it this way because that's releasable. I don't want to do it this way because that isn't. that's what I would like to know, you know, how much leeway we have in here in terms of confidentiality. I felt like it wouldn't be much, but
First, I think it would be, if I could see the briefing, if you could share that with, I'd love to read that, because I think that would be helpful in getting through that, and I don't want to comment on what y'all briefed up without looking at it, but I think, I like certainly the approach that that's being taken there. I don't think, as I said earlier, as far as what's releasable, I don't think that's going to change. That's not going to change. Under civil service or 4535, the same type of information in the hands of the agency remains confidential. That's my reading of the statute, and I don't see any intent otherwise that would change that. And I don't see anything that would change what would be 6 months ago or a year ago that would have went into the G file and been confidential. I don't think anything changes that now either.
I agree, but I'm wondering if, since we're contemplating this entire statute as a committee and we're allowed to make a model policy, how much leeway do we have in that model policy to do things like protect information that's unsustained or direct agencies on how to compile and what files they go into, because, you know, all of our agencies have different ways that they're maintaining these files.
Yeah.
So, just one point on the records and stuff, it's, that, we're not freestanding, we've got the Records Retention Act that applies to some of these records, so we couldn't necessarily just say, you know what, we no longer need to come out. There are some statutory requirements about some records about police officers.
I think we should look at those when looking at this model policy, because I know, like at Austin, for example, there have been, and you probably know more about going further back, but even when I was there were records, we had something called training memos that just popped up out of nowhere. Yeah. And we were told that they would disappear literally within 12 months, I believe it was. Yeah, they were retained for X amount of time, and then they're gone out of your file, allegedly. So again, I think this is the perfect opportunity to say what you can and can't do, because I don't know if that was proper or not. Maybe it was proper, I have no idea.
When we do that in Dallas, on the lower discipline stuff, it's in your file 6 months. You go check your file, it's literally gone.
And where does it go?
It's gone. I think just throw it away, shred it.
Is it pursuant to a secret collective bargaining agreement or something?
No, it's just that's been our department. We're under we're under chapter 147. We're a little bit different. But no, that's just our policies in Dallas. This low minor stuff, you just get like a document counseling. 6 months it's in your IED jacket and it just disappears. They literally take it out and go.
I just think this is where we could.
Which is fine, we don't mind. We're not objecting.
Universal.
But that's how different everything is though. Yeah, Jennifer's right. Should my department keep keeping it? What is it supposed to be?
Y'all really stirred the pot right before breaks. All right, we're going to continue with literature review. Theoretically.
Would it be beneficial if we just kind of went through this overview all at once, or do we want to kind of continue question and answer? Do we have anything, comments or questions about anything we've covered so far? Okay. I'm going to refresh this. Let's go back to the top. We know alleged misconduct required an initiated investigation. There was some discussion as to, we're talking about, misconduct means. The question we had earlier was, may suspend, demote, or terminate a license holder's employment. Under the definition of misconduct, there was some discussion as to the committee would either now or down the road discuss to what level, discuss the word may with regard in relation to these disciplinary actions. We talked about sustained, whether the allegation is sustained or not, and where it goes in the agency files depending on the disposition. We talked about the personnel files under Civil Service 143-089A and 4535. Those are the sustained misconduct. The unsustained would go in the 143-089G file, and we discussed the corresponding for name for no other lack of term, for the 4522 file for now. We talked about the confidentiality of these provisions, and as those were things that we're going to need to tackle moving forward. I know Jennifer brought up some briefing that had been done in regards to the AG's office regarding the confidentiality of G files and whether or not they exist or not in some scenarios. I think that might be useful. We get a chance to review that and talk about that as we go down the road. We discussed some possible designations for non-civil service cities who have everything that does not go in the personnel file, where it fits over here, and possible claims of confidentiality, as there is not an express provision in SB 1445. How we can maybe tackle that moving forward. Some thoughts on that. And let's talk a little bit about committee members you have before you. It was passed out prior. We have the first draft, and this is, again, just to discuss the concept and talk about the concept. And it was brought up, Chief brought it up earlier about replacements for the F5s, what's analogous to the F5s. But let's talk about what needs to come to TCO after the agency's sustained or not sustained particular information on an allegation of misconduct. Ultimately, taking away, let's leave beside, let's set aside a second for the agency files portion of it. Let's talk about what TCO gets. Let's go back here to the top. Every time one of these allegations is investigated, and there's a completed investigation, it goes through the internal due process of the agency. The agency places it either in its personnel or unsustained files, depending on whether it's civil service or not. Let's talk about what TCO gets as a consequence of these actions. Essentially, there's two types of reports, or two types that are reports that are contemplated by the legislation. They have different timelines, and you'll see that the one before you, it has this information combined on it. Again, this is just to give a concept of what would come to TCO as a result of a misconduct investigation at an agency. Let's talk about the first kind, the criminal charges filed. And these are parsed out, of course, in the statute. I believe this one is under 4522. If criminal charges are filed, the agency must submit a report to TCO in a timely manner after the investigation is completed. Looking at the words timely manner, it's terms of art. That's certainly something the committee will need to come up with, as I have noted here, what a timely manner means, whether that's 30 days, 60 days, whatever the case is. That's a policy consideration for you all, and as we move forward to discuss and consider. On the other side, as a result of any alleged misconduct investigation, everything else that's not criminally related, you submit the summary report. The wording's a little bit different in this provision. This one will be, again, in your notes, 4522 B1D and B1F. All other investigations, and I'll blow this up. Submit a summary report to TCO, including disposition of the investigation, informational findings in a timely manner in 2 instances. Not later than 30 days. My reading assumes that this is if the licensee is still employed with the agency, event, investigation, final, report to TCO within 30 days, or 30 days after the separation of the licensees. And Jessica, thank you for drafting up the initial reports on these. Does anybody have any thoughts or questions about the procedure, the general procedure that we're looking at here as a result of the agency level misconduct investigations and what goes to TCO and placed in the confidential database in terms of misconduct reporting?
John, when you talk about criminal charges filed, are you talking about criminal charges filed, let's say in Dallas? Okay, I've got a Dallas officer, and my department is filing criminal charges. Does it also encompass
Everybody?
if criminal charges are filed against one of my officers in a different county or something? Yes?
That's a good question. Let's look at the statute, because we had this discussion when we were putting together the flow chart. We've got the personnel file and misconduct investigation side by sides. Let's take a look at it. Let's go to 7, I'll get you there. 1701, 4522, B1C, and B1F. Let's take a look on the blue box there. Thank you, Aaron, for color coding these. Looking at B1C, as we all see, for which criminal charges are filed, and it does not have by the employing agency, it doesn't distinguish it that way, or it doesn't say any agency. I certainly think that's a policy. The scope of that can be determined by this committee.
And this is separate from the other form that we already have to file, both the employing agency and the arresting agency, right?
That's correct. That's correct. The E1 that comes from, as it is now under TCO rule, you have the arresting agency, the employing agency assume that the officer is appointed with an agency, and also the licensee themselves has a duty to submit to TCO notice of arrest, indictment, or other disposition of criminal charges.
But the two could be combined.
Yes, absolutely.
Two reporting requirements.
Yes, and I think that as we go through this, that's going to be kind of the purposes to relieve some of that reporting duty, because we'll have that report already coming in. So we don't want to make any redundancies on behalf of the agencies or anyone else that has to report these.
And when it says summary report, do we envision that will be a new form from TCO, or will it just be a memo or whatever the department's already doing?
I think the misconduct report that we have before us, I think we can have, we suggest it be a standardized form, that you have one combined form perhaps that has both, if it makes allowance for the criminal misconduct or the administrative. So you're able to check the boxes, fill in a narrative if it's required or necessary, and have it in one form so the agencies know exactly what it is they have to do in response to an alleged misconduct investigation.
Said differently, however, that's more workload on the agency, because not only are you doing your complete investigation, you're now having to retype that investigation into the summary and the investigative and informative findings. It's twice the work versus see attached.
So one of the things, again, I didn't see in all the statutes you listed, it's 174. So I just, again, we're gonna get into some of these, where we're gonna think we're gonna do a job, and this 174 is gonna say, doesn't apply here.
Yeah, I'm unfamiliar with 174, but certainly if anyone else has any thoughts on that, and I can certainly get up to speed on it.
It's just a collective bargaining.
No, I appreciate bringing that to my attention.
Kind of like the Death Star though. How should I bring that up? Can it supersede, that is the question that hasn't been answered yet. We were asking it right now.
Yeah.
With civil service, which is essentially the same question, which is we already have a contract in place or a collective bargaining agreement, and so can any of this stuff supersede that? Which normally the answer has been no, but lately that's been.
I didn't see any reference to changing that, so I think it's important that we understand we might leave here doing a job and thinking we've done a job.
Sure.
And not be the case.
No, I think it's a good question, and I think along with the other briefings that we've talked about, I would love to see some thoughts, or if there's been some movement on trying to resolve any tension that's between 174 and these provisions. Certainly, that would alter the course of everything we're doing here, or possibly altering the course of everything we're doing here.
And because we're not under 174, 140, we're under 147.
Yeah.
In Dallas, so we're different. Again, we're different from most.
And John, on these, these are only being submitted in case of a separation, is that right?
No, these will need to be submitted.
So why are we submitting that to TCOL if there's no separation that occurs? If TCOL's not doing anything with it, what's the purpose of it being in there unless there's a separation?
It's to ensure, my reading of the statute is to ensure that every one of these investigations are parked in a repository to indicate, one, that they've been done, and two, what the resolution was. And that's just me reading the whole bill, and that's my takeaway from it.
That's what I understand too, and that's why I was suggesting this misconduct report that's before you, that we add some things to show the compliance with that. In other words, I would list the source of the complaint, so that when we get a complaint that the agency refused to investigate something, we can connect the two together, right? That I can show that this complaint is complaint was investigated, and that it outlined the specific allegations of misconduct, because what they're going to report is either something that doesn't need to be investigated because it's not a policy that could result in suspension, demotion or termination, or it's not untruthfulness, or it's something that should be investigated, and there could be 4 different ones, and you're going to want to show the disposition of each of those to be able to show that you complied with the requirements of law and investigated each of those allegations.
But if the department chooses not to investigate something, and I'm sure you've gotten phone calls from citizens asking you, TCOL, to investigate something. Now, we're the stance on, you don't need another investigation agency. You've got your local, you've got DPS, you've got the FBI, you've got all this. So in no way, if you heard from a citizen and you look at James Parnell and go, well, we don't find any kind of investigation for him. You don't investigate. You tell the department they need to investigate. No.
That's the question, is what the result of this will be. Right now, we have no jurisdiction. You're right, it's the agency's responsibility to address a policy violation. The question is going to become, now the law requires you to investigate that. If an agency simply refuses to or does not investigate, then how is that going to be addressed? What these reports will do is document that you did comply with the law and you did investigate, right?
I think to your point, James, I don't think there's anything that's saying that now TCOL would investigate those complaints. I think it would be TCOL looking into whether the agency has complied with their requirement.
Yes.
And that's, see, that goes back to the very first point we started. We're going to force people in the shadows again with this, because if it may result in this, then I'll just say it won't. I'm not saying I'm doing it. I'm just saying, people are going to find ways to say, it wasn't going to result in that, so therefore I didn't do it.
Sure.
It's a violation of policy that arguably the agency would have in writing somewhere that this policy could. It's not what did they elect to do in this circumstance. It's, does your policy say you can suspend or terminate, or the other language? So it's going to point back to policy. One of the things we've seen the last 2 sessions, didn't make it this time, but this push to accreditation is one of the things that I think we're going to see more and more of, where policies are going to start to coalesce around whether it's the chief's best practices or something to that nature. So I think you're going to have, if your policy says a violation of this may end up in suspension,
So, again, I'm not arguing. I'm just trying to help here. But I've seen some of these things. Again, do the kind of what I'm suggesting, to just kind of do crazy stuff, weird stuff, and put people in the shadows because of that. So if we're going to say may suspend, demote, or otherwise, I'll just make nothing. In my department, suspend, demote, or otherwise. There's a lot of stuff that goes on in an agency already that isn't captured here in this right here, and ought to be captured. I'm not arguing against it. I'm arguing in the broadening of this, so that there is no wiggle room, or at least minimize the wiggle room.
The only thing I would say to that is I would just remind everybody that this is a recorded session, and citizens will be watching this. And our citizens, when they hear comments like that we're just gonna push this into the shadows and we're not gonna hold people accountable, is probably contrary to what the intent of the legislature is and was. And so, I'm sensitive to what you're saying, Chief, but I think.
I'm gonna say what I'm gonna say. You're not gonna police me here, what I'm saying. My comments are my comments.
But let me just finish my comment. I think we all agree that the may is problematic language. We've already landed that plane, that's an action item. Our task is not to say should agencies be investigating bad cops or not, that's not our task. So, let's move the narrative. Keep going, John. Sure.
I would like to say something about, I think this is a big shift from, I understand that prospective agencies need to see the whole picture, and that's what we were always getting at with the sunset process and that's why we were okay with a lot of this, is because we don't want to, I think someone mentioned gypsy cop, which I don't like that phrase, but this was all centered around, making sure that everyone's held accountable when a prospective agency is looking to hire someone. That's what this was, the framing of this, was that narrative. So now, this is in my opinion, overreach by TCOL. I don't think that TCOL should have a repository for every single violation or misconduct. And when we talk about may suspend, I mean, almost everything to an extent could be a suspension, because if it's your third time to crash, then it could be a suspension. If it's your first, it's not, but still, that would still fall under may suspend. Like the chief said, I mean, there's just too many things that go on in departments, and they should be able to do these things without having to double their work. So I mean, I don't know how much flexibility we have here, but I think this is a significant amount of work for everything to be going into, we're taking away basically the power and the vested in our chiefs and sheriffs to do their job. I mean, I think they're doing their job. What I think there's been a failure of is the communication between agencies when hiring new officers, and that's what this was going to fix. So, I mean, I don't agree with the spirit of a repository for the entire state for every single misconduct. I mean, this goes all the way down, and I realize we're going to talk about changing the may, but this right now, as it's written, would be thousands of complaints. I mean, there's so much stuff that
I agree.
really happens.
Even as a best practices agency, it doesn't define who will be suspended or demoted for this. So, it's still open to interpretation based on the investigation. So when we would get one, it was based on that information. But I agree, because there are issues within the agency that third-time wreck, something, aggressive disciplinary-wise, it may lead into suspension, and that's going to be a lot that's going to be going into the system. And I don't necessarily know that's going to change a prospective employer for hiring somebody. I don't know.
Yeah, Jennifer, just to back up, I think I was under the same misconception as you were, that this was strictly to talk about misconduct investigations for the hiring procedures, not, and that's also how the statute is titled, misconduct investigations and hiring procedures. If we were just talking about model policy for misconduct investigations, I would have thought that would be its own separate. I thought this was very contained to just the hiring and the firing, and if that's not the case, then maybe we can, I don't know, I guess I'm confused then.
Yeah, that was never part of the conversation, at least that I took from it. And I know you and I were, I don't know everyone. I'm not seeing anybody else that was in a lot of the long meetings, but that was not.
So is TCOL's interpretation that you will be the repository for every single misconduct investigation that occurs in the state by police agencies?
It is for each one of these reports, certainly. We can certainly go section by section through the act, and that's, let's take a look at it.
It says submit to the commission each report of of a completed investigation. That's straight out of Senate Bill 1440.
But again, that was always in the context, in the conversations we were always a part of that this would be basically replacing the F5, forcing investigations in certain cases, and would only occur upon termination or separation of any kind from an agency. So, which makes sense, because why do we need a repository unless someone's gonna go in there and look? And the only reason someone would go in there and look is if they are going to hire someone. So, it's like we're just, and I understand the compliance piece, that's the one, but again, the compliance piece to me, I get it, but that's, to me, it's overreach. I mean, these people are elected in some cases, or hired by city managers and council members. I mean, I think that we have to trust our heads of agencies, and I'm not saying they're all perfect, but this is a big step that I don't think anybody in our conversations thought we were getting at.
And the question is, during your 8 years at APD, if there were 10 allegations of misconduct, if they didn't investigate any of those, are we not going to find out that you separate? Right? The purpose of that report is not the entire investigation report. It's a summary showing that you complied with the requirement of law to investigate, you disposed of the allegation. That's all you're reporting to TCO. You're not sending the entire investigation here. Right? The summary report just shows we received an allegation, we investigated it, we closed it, we complied with the law. That way, when the entire file comes here, we know that there's not 8 years of allegations that were never investigated.
Well, how do you know that there's an allegation? If they're going to report the allegation, I mean, how do you know they're reporting the allegation again, like the chief was saying here? Like,
That's
just
the
because
next
it could
question.
be
When we get a
squashed.
complaint that I made a complaint and they refuse to investigate, then we go back to see whether there's.
But what if it's internal stuff? That everything we investigate isn't internal? I mean, isn't an allegation. It's something that a supervisor recognized and they want to address. That's not an allegation. That's what most, investigations, I don't know if we would even, that's the thing, we don't even call them all investigations, because a lot of times, the majority of discipline is done at the sergeant level where they see something, because they're being proactive. And I agree with the chief, I have no problem saying it. It's going to change the way, the people do things. If they're required to document every single thing, if I want to tell my officer something when I was a corporal, I would just drive up to their door and say, hey, do this, do it better next time. This is what I saw, do it better next time. You can do that, but, the idea, and this is the irony behind this whole activism movement, we want them to do that. We also, are okay and proponents of documenting things, but not if every single thing you document about an officer's, where they could have done something better, is open for the public to see. I mean, other agencies, that's fine, but again, we're talking about, we don't even understand the confidentiality of what's going to happen here with a lot of these files, the repository. It's just not part of our thought process.
Well, I know you referenced some discussions that certainly I wasn't privy to, but I will tell you what occurred during one of the Senate hearings. And one of the questions that I received was, how do you know what's coming in these files that another agency down the road, what ensures that there is anything in that file, if at all, that documents misconduct, good things, whatever the case is? And the response was, there's no requirement for anything to be in some of these files. So that was part of the reason for coming up with a standard for the creation of, in the instance of one of these, violation of law, policy, which may result in discipline or untruthfulness. That's the standard for the creation of something to go in that file. So an agency down the road, which we were talking about that, which was your understanding of how this fits together. This is the creation of something to be there, a requirement for something to be there related to misconduct that was not there not been there in the past.
So if you adopt the model policy but don't require them to place it in a repository with TCO, they would still be, by statute, required to conduct the investigation. They just wouldn't be required to enter all that information into a system. And again, that's, to me, makes a lot more sense. And also would still have a compliance mechanism, because if a separation ever occurs, which 99% of the time it's not going to on these things being entered, but if it did, you would be able to check compliance on that at that time as to whether or not that agency was actually investigating thing.
So Jennifer, what you're saying is that anytime one of these reports that's a result of an investigation, sustained or not sustained, those don't go to TCOL then, they go only after separation.
Yes.
Okay. My question is, if that's the case, I think Stan mentioned earlier, agency must submit to TCOL each report of a completed investigation. But we're talking about, we're on the same page with that. The question is that during the point of appointment or only after separation? You're saying it's only after separation.
Well, in the file, and correct me if I'm wrong, because I have never been in secure shares. I don't know what that even looks like. But I know it's supposed to be in there. So if an employee separates, and let's say we had a policy with a month on investigations, and then 10 years in they separate, you should be able to see from day one until the end, that last misconduct, if it was misconduct, what all occurred. And if there were allegations, investigations, and whether or not they complied with the policy.
Well, to our point, it does say, as it relates to reporting to TCOL, in a timely manner, but not later than the 30th day after the date of the license holder's separation from the agency if applicable.
And that's why it was always under that understanding that this was on separation.
But in that case too, at the very least, alleged misconduct, criminal misconduct, that doesn't have, but not later than 30 days after separation. That indicates that it needs to be during whatever y'all view as timely.
Timely manner after the investigation is completed per statute.
For the criminal side?
Yeah.
Correct.
Yeah, we don't have a problem with that. Criminal, different.
It's definitely a different way of reading it. You understood that too?
Yes.
In all these negotiations? TJ, I have a quick follow-up question. You said that we're not going to actually submit the actual investigation. We're only going to do the summary, but it says on section F, submit to the commission each report of a completed investigation. In your mind, that's this summary document?
I think if we're discussing, you're gonna close out and notify TCOL that you investigated and closed it out, that would be a summary report. It's not your entire investigation. I don't think it anticipated it being.
Perfect.
And Stan, keep in mind that it has alleged administrative misconduct, submit summary report.
Yeah, okay, thanks.
So, you certainly,
Take your hands at Houston PD for that.
For which part?
The summary investigation versus the full contemplation of a full investigation.
Right, because our investigative file can be very thick, and if we're, the volume would be
Yeah,
tremendous.
audio, video, everything.
Exactly.
okay.
And I understand the two interpretations, but again, I go back to someone in the course of a 20-year career there's 5 allegations, all of them investigated, not sustained, you're reporting to TCOL in a timely manner. If they quit under investigation, now that timely manner has been said, can be no more than 30 days later on a deadline. But I don't see how the first one conducted in year 2 of their 20-year career isn't resulted until the end of 20 years and is considered in a timely manner. If the idea of these summary reports is to show compliance with the expectation that every agency will investigate every allegation of misconduct, which I agree is incredibly burdensome, and part of it is defining what is actually corrective action and what is an investigation of misconduct in that model policy to give them the freedom to only put certain things in that category.
I remember early on there was a part of the bill that what didn't make it to the end, but it talked about just egregious behavior, which is something we can define here.
Yeah.
So yeah, I mean, if we could like really narrow it down, or again, I'm all for if it's separation only. But I think this is way too much information going into it.
Well, that's certainly y'all's charge, determined in a timely manner or no later than 30 days. So there's quite a bit of policy determination for the committee to undertake there.
What does the rest of the committee think? How are you reviewing the statute? I think she brings up a good point. I think there is some discretion allowed, but I'm also sensitive to what TJ said. And is the agency going to even remember to go back into year 2 at the time they separate 20 years later?
Someone point out on the bill exactly where we're looking at.
If you have a numbered version, 1445?
Page 31.
But they wouldn't really have to go back, would they? Because wouldn't everything be in their file on separation?
That's right.
It would already be there.
But you'd have to go back and do a summary report of that sustained IA in year 2, in year 5, in year 7.
I would submit that only a summary report would only be required for the separation portion. Everything else, the enforcement would look at what was done leading up to this and was it in compliance with investigations that shall be conducted per the model policy that we all adopt.
So officer commits misconduct year 20, but he's had a series of sustained temporary disciplines leading up to this. You're saying that we would only submit the summary report on the actual one that caused the termination?
Yes, but you're still submitting everything into Secure Share because that's a separation. So then for prospective agencies to see. And so TCOL would be able to see the entire file.
But we're not submitting those completed investigations to Jessica's point into TSS.
So how much information are you seeing in enforcement on, currently, on their file for an investigation that occurred?
So, to clarify, agencies are only submitting to TSS when another agency is doing a background and looking at that.
She's just referring to the portal. We wouldn't use TSS, we would use a different tool. You're talking about some portal to share information.
Yes.
Now, that's current.
TSS is for agency to agency sharing. If we created a way for you to send those records, it would have a different title, I'm sure Jessica would say. You can repeat your question.
So, what would you be able to see if we did it this way, the way we're discussing? What would you be able to see in terms of what's occurred with that officer prior to that last nail in the coffin, if you will, where they terminated because of misconduct? So you would see the summary report for the misconduct that led to their termination or separation. What else could you see? They're required to submit. If they have to submit information for prospective agencies, you can see that, correct?
I see this shared through TSS.
Can you see any of that?
Not right now. No.
Is that something that we could do then? I mean, could we open TSS up to where the enforcement division could see it? For compliance within our model policy, so that they can see.
We're moving really fast, John. It might help, I think, if we just define what has to be shared at separation.
Yeah, let's back up a little bit. So I want to make sure if maybe I'm misunderstanding, but if the proposition is that an agency only has to do an alleged misconduct investigation upon separation, is that?
No,
okay.
they would only submit
Okay.
those into the portal.
Got you, understood. You're talking about submission, sending
Yeah,
everything at the
submission.
end. Okay.
John, I think it would help if we could talk about what is going to be shared at separation, because I think that changes on internal affairs investigations and those things, what's going to be stored and kept.
Sure.
Because I think that the summary reports are a different tool for a different purpose. And
Agreed.
If we talk about the separation, it might make that clear.
And this goes back into, now we're talking about, you have the misconduct requirement, each instance of misconduct, and we're talking about, well, when do those go to TCO? When do those reports go? Now what we're talking about is the background and hiring procedures, what we talked about, that's a separate part of it. Ultimately, at the end of the day, in this confidential database, let's go back to our first starting point. All the personnel files, all the records that we discussed will go into this confidential database for review. Is that what you're talking about, TJ?
When someone, and make sure I'm phrasing this or understand this correctly. Right now, if someone leaves your agency, chief, and I want to hire them, you send through TSS so that I can review all those files. The anticipation is that at some point going forward, he will send those files to TCOL, all of those things listed there, and they will reside here. And if you work 3 or 4 agencies pass on, they will all reside here. So an agency, rather than having to request from individual agencies, will simply get all those from TCOL.
That's what I understood in the first hour.
Okay, so When that file comes, that will include your internal affairs investigation in a distinctly different manner than that summary report, right? This will be more inclusive, it will be more detailed, it's something that another chief administrator will review to make an informed decision in hiring. The purpose of the summary report, I think, is a different purpose. I think that's what was anticipated, that was to show that we are investigating allegations of misconduct. The biggest example clearly is those who separate under investigation or under examination, right, that was contemplated. But if the purpose of that summary report is just to show compliance with the law, then I think it has to show compliance throughout that person's career, not just that separation. And I understand your concern. I just want to make sure that we understand you will actually report some things twice. Once in a summary report showing that a complete investigation, and later in a more entire fashion at separation.
But why, to her point, because if the goal is to ensure the next agency can make informed decisions, why then isn't that TSS sharing the most thorough record? Why do I need this second standalone records of these completed investigations that you just admitted are completely incomplete?
That's exactly my point, and I think that's why the legislature has it in two different places. One is to show compliance with the requirement to investigate. The other is to allow chief administrator to make an informed decision. Does that make sense?
So the legislature is going to basically monitor us and investigate our employees?
Yes, that's the whole purpose, which was not shared with us as the intent of the legislature.
Now, when we talked about summary report, we were talking more specifically about a synopsis for an internal investigation, like not sending the entire package.
Right.
So that's what summary report meant when we talked about it. It was just very basic information about the complaint for the potential hiring agency to see, as opposed to submitting, the entire investigative.
And nobody's gonna want that entire thing, especially if it's a, unsustained, or they're not gonna wade through all that stuff. And it could harm the applicant if you've got a G and stacks of paper on stuff, nothing was sustained. You're looking at all that going, well, there's smoke, there's fire.
Right, and so that was the impetus for the summary report. It was just a basic explanation of what the investigation dealt with.
Because that gets into a problem when I think of my detectives and vice and narcotics. Big cities, they get allegations against them all the time. I mean, my detectives in narcotics and stuff, the defense attorney, first thing they say is, hey, go file a complaint against this person. So I can have a detective with stacks of, alleged complaints. Where you're going to have a summary on all those, and just like what she said, you're going to look at an officer that wants to go somewhere else and say, oh my gosh, he's got all this in here. No, it's...
I'm going to just say this as maybe one way to begin to cure this right here is be real strict on what suspend, demote, or terminate mean. Because if you look at the legislation, at some point in time, you're required to investigate every time somebody makes an allegation, which most of us do, on a continuous basis. I would say that a lot of those investigations are administrative and they don't result in suspensions, demotions, or terminations. So therefore, doing the investigation and having them not qualified for this doesn't require me to report to this. I just think we need to be real clear there. Now, I'm going to give you a scenario where you've got, let's say, somebody said an accident here, an accident there, an accident whatever, 3 times. Maybe the 4th time, an accident on its own is not I'm just using this. I'm not saying that it is, but an accident standing on its own, an accident investigation standing on its own may not be suspended, demoted, or otherwise. But God, this is his 4th or 5th one. I may do one of those things and still be outside of this right here, if the accident investigation on its own. So that's the kind of thing that I'm suggesting to you. We got to be real careful. So maybe one way to fix this is be absolutely clear about what suspend, demote, or termination may mean. And maybe that's what we start on the first line in terms of, okay, where is this going to apply?
And to your point, the problem, if I understand, because I agree with you, because that's just the way 143 is operated. But this is a complete paradigm shift, because it's now saying all investigations will go. It doesn't matter if it results in suspension, demotion, or termination.
Well, it says allegation of misconduct requires you to investigate. So what does misconduct mean? This right here. And that's what I'm saying, if we're going to not necessarily carve out some things, but carve out the requirement to the reporting process, be absolutely clear about what is suspendable, demortable, or termination. And maybe that, I don't know what the ratio would be, but maybe that clears out 60% of the stuff that we're talking about. So on the investigative reporting piece of it, okay, I think, like she was saying a minute ago, we're already required in a separate piece of the legislation to establish a file that has X, Y, and Z. So where an item was acted upon and it was not reportable this way because it was neither suspendable, demortable, or terminated, it's going to be in the file whenever the file becomes available to somebody that's going to look at that. So it's not like we're hiding it away. We're just trying to be absolutely clear as to what is subject to the misconduct reporting policy or layout that we're talking about. I don't know. Just an idea. I mean, and if you look at 143, for example, disciplinary suspensions means something. Anything less than that is something different. So maybe, I don't know, Houston, maybe something similar, I'm not sure. You're over a million, so therefore, I think it's the same line for me.
I guess I'm just still a little bit confused on the scope, and maybe it's already been determined, but this is for everybody, for everything, not just on separation? That's how it's going to be?
I'll read the top. And agency required to initiate investigation into alleged misconduct at the time the agency becomes aware of the alleged misconduct.
Sure, and I guess I'm not concerned about the investigation. I'm actually more curious about 4522B.
Sure.
D, the submitting to TCOL in a timely manner.
Sure.
I was thinking, again, to reiterate that that was upon separation only and not every single investigation ever. Right, yeah?
Yes, is that something that we can amend at this point?
I think if you're talking about when, I certainly think it's within y'all's ability, in y'all's discretion to say, okay, all the reports get submitted 30 days after separation. Because that's certainly within on that right-hand side, that's certainly the when it gets reported. Absolutely up to y'all. But if your question is it just a one-time investigation or one-time report or every report that has occurred over the course of the appointment?
I guess my question is, I don't intend to leave the Houston Police Department.
Yeah.
Does that mean that any investigation into me will be submitted to TCOL? Or is it not until I decide to separate that everything goes to TCOL?
And I think that's exactly the question. When it gets submitted is in y'all's hands. Now, we know on the criminal charges filed side, in timely manner, however long y'all say it is, 30, 60 days, whatever the case is. That's clear, when the investigation is completed. That's no or anything on that. This, to y'all's point, if y'all want to make it at the end of separation, that's certainly up to y'all.
What would the point be, though, if you had somebody that, let's say they retired?
That's certainly, that's the other
But
side
they
of
wouldn't
it.
have a report. If they retired, there would be no misconduct report.
But there's,
That's a separation.
Right, yeah, it's a separation.
What if you had 10 of them and you retired?
And that's why I'm suggesting maybe you hammer out what the separation packet is gonna look like.
Yeah.
And then work backwards from that to see if there's other reporting requirements that precede that by the agency. I think if you define what has to go at separation, then it makes sense if there's other things that have to be reported prior to that.
And then how long do you have to keep it?
Yeah, how long does TCOL keep it under this?
I'll look up the specifics. It should be a while for our records retention, yeah.
Well, that's what the agency's record retention. So if they have something they investigate and they don't, there's no change in status in the officer, and they just put it in the file, how long does that have? Like Dallas PD did the same thing my former agency did. You got like a, you know, ours was a, I forgot exactly what it's called, but it's essentially just a written reprimand, so to speak, and after 12 months, it was investigator responsibility. He went to the supervisor, hey, it's been 12 months, can I really remove my file? And they removed it. So, and that did count as a form of discipline,
So,
even though it wasn't permanent.
I think that goes back to something that Chief Rodriguez had said. We are now charged with potentially narrowing the scope of the type of allegation. Not so much the outcome,
Up here,
but the type of allegation, yes.
then we're on the same page there.
Right.
I'm with you.
So your written reprimand would not necessarily, I'm sure would not fall into something for which you could get suspended, demoted, or terminated.
It could though.
The May is talking about what you have to investigate. Right?
Yeah, and that's,
And then the retention is a whole separate, and there is a separate section that talks about if discipline is administered. It has different wording there.
Correct.
What's up there is only the trigger to require an investigation.
And there's certain conflict in there with the opening there, and this is requiring the investigation, and then the permissive language under May, suspend.
But it has to be permissive because it hasn't been investigated yet, so we don't know what it's going to result in.
I'm not arguing, I'm just saying,
Right. If I fail to do a radio check in the morning, I can't be suspended for that. You can let it it doesn't require investigation. But if I'm involved in a collision, and sometimes we suspend people for collision, then there needs to be an investigation. I think that's what it's intended. I know, I agree with you. We'll find ways around it. They're going to try to waffle on the words, but just to make sure that, I think sometimes we're talking about two different things. This is only the trigger that requires an investigation, not what gets retained.
you know, we're trying to do a whole bunch of stuff in there. What do you want to, what does TCO want to do? I mean, maybe that cuts a little bit, I don't know. We're going around in circles in this. We're kind of chasing our tails, so to speak, in this discussion about what we want to do here. We're not clear as to, we're clear this is going to require an investigation. We're clear that this is going to require some reporting. Well, we're not clear as what reporting might be eligible to this. So if we agree on that, let's work on that piece of this.
Sure.
As to, I don't, I think we've got a lot of, there's some wiggle room. I think more wiggle room in an agency may suspend, etc., as opposed to the reporting requirement. There's more wiggle room there as opposed to the reporting requirement. That's pretty clear language to me in terms of, if you have information on a particular misconduct allegation, you will investigate.
Each investigation.
So what is misconduct investigation? What is a misconduct? What is misconduct? And this is what I'm saying to you is, let's go back to this premise right here and let's define what can be suspended, demoted, or terminated. And let that be at least the area that we can give us the breathing room that I think we're trying to find here. Just an idea. If this doesn't go away, then that's an alternative. And this is a piece of law that's not going to go away, at least not tomorrow.
It's certainly not going away.
I think like Jessica said, if we're able to minimize the reporting requirement, then we can be more honest about the model policy that I think everybody really wants to adopt, which is, a meaningful model policy for agencies that probably need them. But if we're going to require this huge amount of workload, not to mention investigators, how many IA investigators are these agencies going to need to hire if they have to conduct a thorough investigation on a may suspend item every single time?
Or even worse, an allegation of untruth.
Right.
Because
those are all rampant, right?
It's just an allegation.
Exactly, that's a good point. So, I mean, I agree with then we can keep the model policy more robust, which it probably should be for accountability across the board. But it's not sustainable for large agencies. It's not sustainable for even small ones because of personnel, but definitely not for large agencies to report
And
this.
again, the end goal is for hiring agencies to have the
That
best
was
picture
the
of
way
who
it
they
was.
are hiring, not
Yes.
necessarily whether or not the Houston Police Department is conducting investigations.
Yeah, because that's what they want to do, chief. They
No,
want to
I
look at
I
what
understand
you're
that,
doing.
but I think to get that, if we leave the secondary piece of this in place, and that is the construct of the file. Because the construct of the file will not leave us any room to leave the kind of things that we're talking about here out of the reporting process.
Yeah, wait till you see what we have to develop with the personnel policy.
So the construct of that file, I think, gives whomever is going to look at that applicant the full picture. What we're talking about here is this investigation requirement and what constitutes an investigation. Misconduct.
See, I'm less concerned about the may, because for me, we have a codified policy that distinguishes between a class 1 complaint and class 2. A class 1 complaint has actual examples, excessive use of force. It's not going to be for the rude, tardy, etc., insubordination, those types of things. So I'm less concerned. So if we assign a class 1, it's clearly fit in here. I think we have to resolve that, but we also have to resolve the issue of when are you going to file that summary report with TCOL. So in your example, you work another 20 years, you've had, let's say, 3 of these investigations. So HPD IA has done 3 summary investigations. Is it your belief that none of those will be shared with TCOL until you separate?
Yes,
And that's your belief?
Yes.
because it doesn't matter in the scheme of hiring agencies what it says, because I'm not going anywhere, nobody's hiring me. Once I leave, then somebody else in the world might have an interest, but
Which is why I asked you, what was the legislature's intent? Is it just really, is it looking to see if we're actually doing these investigations? Because on your paradigm, they wouldn't know.
Apparently, but that was never discussed in any of the meetings. That was,
That's right.
the intent was always for prospective agencies.
We're probably too far in the weeds to get specifics, this or that, but again, if that's the policy direction that y'all choose to go, is these all come at the end versus during, that's certainly within y'all's parameters.
If we don't work on this, I'm telling you, every supervisor does investigations on personnel. They walk in late to roll call today, they might get a, don't do it again today, but tomorrow they walk in, now they're gonna write them up. That's according to this, if we don't narrow this thing down.
I get where you're coming from, I'm just thinking about this, Chief, I don't interrupt your thought. Maybe, and we're thinking aloud here, I'm throwing an idea out here. Violation of law enforcement agency policy, which the agency may suspend, demote, or terminate a license holder's employment. Those are pretty severe actions right there. Those are actions against, you're being demoted, you're being suspended, you're being terminated. So maybe I'm looking at it from that perspective. I view those as being very serious events that relate directly to the employment of the licensee. Not you were late for roll call, you left a bag of chips in the patrol car, whatever the case is.
And I agree with that. The only thing is, we've got to do this in a way that's going to give, if I'm the chief and I share your thought here, and then you come in and say, well, I don't agree with you, you should have done this. Who's going to cover him? The chief or not apparently looking at it the same way you're looking at it, or Neil. So that's what I'm saying. I go back to this. The beginning point, I think, might be in absolutely defining what is suspendable, demotable, or termination. And maybe we develop a class of offenses or something, and maybe that narrows that box a bit.
I wrote something down earlier about a tiered approach.
Yeah, we have some policies like that. That's separate, just like standard flat. We have informal and formal. So we either have in inquiries, we actually do a formal complaint. They actually list excessive use of force, racial profiling, those allegations, which that would fall under the category for the suspension, termination, or demotion. The other stuff is the motion will receive unless there's something else in the background would be written reprimand counseling, something along those lines.
and so again, for some context, the reason that the alleged misconduct thing did not feel like an issue during the time was because it really was just the stuff that I, as a hiring agency, would want to know. And so we weren't reading that to say that we needed to draft policies for any kind of misconduct, tiered approaches, whatever. It was just, these are the things that agencies should be investigating, or these are things that an agency should expect to have investigated when they're looking to hire somebody. So we were reading it in a much smaller framework than I think you guys might be, and that might be some of the issues.
No, I think that's, I think we're exactly where you're at right now. I think so.
It was specifically addressing the problem of people leaving agencies and no investigation was conducted. It was trying to plug that hole.
Right. Not is Stan's agency investigating the same way that I'm investigating. Stan can do whatever he wants, but when I hire his agent, or his officers, there's an expectation that he will have done an investigation on these high-level things, untruthfulness, or something that they could get directed for. Because that's what I care about, and my community cares about when I hire.
That's why I think we can easily define the thing. We can also
Yes.
easily break for lunch. Just get clearly your fault. So,
I'm ready.
we could have already been well fed by now.
Besides who they hire the chief, are they required to do anything to hire a chief of police?
If that person is a peace officer, then they have to comply with 1701, 451.
Can I circle back to what you said, because I think it was a pretty good tension, and I'm not really sure where you're falling. And I want to reinforce what you said. At large, stable agencies, it's probably pretty simple to do it at departure. But let's take the smaller agencies, and let's get a worst-case scenario. An officer is arrested for aggravated sexual assault because he sexually assaulted a 13-year-old stepdaughter. There's going to be a very public outcry why this Texas police officer did that. And they're going to ask lots of questions. And then they're going to ask the question, was there any previous misconduct and was it reported to TCOL? Under your all's paradigm, nope. And how is the agency going to withstand that backlash because they didn't report in a timely manner?
But there's a distinction between criminal charges. In that example, nobody's disagreeing that that should be reported to
No,
TCOL.
I'm going back a year. This one's a done deal. We're going to report this one, but they're going to ask the question. Let's go upstream.
Why do we need to report any previous misconduct to TCOL?
Because it requires in a timely manner that I want to report any serious misconduct that would have resulted in.
Well, we're saying we disagree with that, and that it should actually only be reported.
But you're sensitive to what he's saying with the small
I do,
agencies?
and I was gonna comment on that, because I do think, I agree with you, there's issues with some of the smaller agencies, but, you know, my question, I guess, for TCOL would be, because there's no compliance piece to this in terms of what TCOL can or can't do in terms of compliance. So they're just gonna do what, they're gonna get all of this information through the confidential database, and then what we're basically being told is they're going to determine whether or not the chiefs are doing their job and sheriffs, as far as conducting investigations. Well, but none of that's laid out as far as what their authority is to do that, how they're going to do it, what personnel they're going to use to do it, any of that. And so, while I agree that there's a problem, I feel like, you know, is there a way that they can investigate an agency or a chief or a sheriff specifically on a specific complaint on a case-by-case basis? That would be much better, in my opinion, than adopting something so broad that they don't have the resources to do it for one. It's not really anything that they've ever been tasked to do. And nor do I think anybody wanted that to be the case when this legislation passed. You know, I just don't see how it's possible that they would have the bandwidth to actually determine, you know, if these agencies are conducting all of these investigations. I mean, thousands of investigations a month with all of our agencies. It's just such a huge piece that we would be asking them to do. I mean, if there's a specific chief or sheriff in Texas that is clearly not conducting investigations on an officer, should we have we do have recourse there already, but, should T-Cole be the investigator? I would be okay with that. There already is recourse. The Texas Rangers, again, we've discussed this and a lot of this, that there's already recourse for, because that would be official misconduct. I mean, that's not just a bad chief, there's misconduct involved in a lot of that. Look, penal code violations involved.
I get that. The thing is, I guess I'm just looking at it more at when would you ever discover this? Now it's too late because I'm not going to give names or anything, but, we had an individual that was working for one of my departments. She had been a investigator, and she was one that came from somewhere. We had no idea where she came from. Sheriff was real proud of her because he had a female that could now investigate about, the child abuse cases, the sexual assault, the domestic violence, and so we brought her in. And she did that for 2, 3, 4 years. Then later on, she got moved to patrol. We were told she got moved to patrol because, there's more money in patrol, because there's overtime, there's this, there's that, okay, whatever. Cases started coming in that she was going to have to testify on because she was the lead investigator at the time. And then all of a sudden, it hit the fan because the defense attorney had some information. We kept asking and said, no, this is what happened. Well, some other stuff happened where a court ruled that they had to turn over the file finding. We got the file. There was a whole bunch of stuff on this individual that probably fell under, not just the policy, but fell under the truthfulness. Basically, she didn't get, move herself back to patrol because she wanted to make more money. She accepted a demotion because she had been caught. They had done a sting operation because she was lying about her time, and she was basically working, doing security work when she was on the clock with, the agency. And so all that came out, and it was like probably 4 years, 5 years worth of stuff. There were dozens of things that never were investigated. They just kind of wrote up, so we had enough to see what it should have been, and it was something that probably this would have triggered an investigation, but they never did any investigation. And by the time it all came out, she had already gone and been hired somewhere else.
I actually wonder, though, if it would have triggered an investigation under this. And the reason I say that is because if you look at it, it says a violation of a law enforcement agency policy. We've been talking about allegations a lot, but a lot of times in other words, they would have had to self-report the initial misconduct to even go into the investigation. Does that make sense? So in other words, if they didn't do it at all, how would T-Cole ever even know to begin with? Because it wasn't an allegation.
Right.
That particular case.
Yeah, they never
wasn't
did.
An allegation.
They never did. But in that situation, if they never did, probably this would trigger that administrator maybe getting in issues because they didn't do what they were supposed to be doing. Now, it's not going to help us on that officer, but it might help in having the agency, follow through with what they probably have on their books already. That's probably their policy already. They just, I don't really want to, she's a good officer. I don't really want to, ruin her career. I don't want to this, I don't want to that. I don't want to put a blemish on. And it's like, okay, but when we're looking at it, it was a stack, and it was like, probably all of these should have been investigated because they had information, but then they didn't assign anybody to actually follow through on it. They just, I guess, talked to her, and later on gave her the option of, look, we can put you on patrol, and then we won't look into it. And so she accepted that for a while, and then when it got bigger because of the case that was coming to trial, she left on her own. None of that followed her, and when we had to bring her back, she was working at another agency far, far away. So it's just one of those things. That's a worst case scenario, but I think that's probably what we're trying to plug the hole on. Not so much, you know, the departments that have a good, solid, you know, system already. It's all these little smaller departments that don't. And then somebody who maybe comes in as a next chief that wants to put something in place can't, because, you know, it's a good old boy system, and you know what, we don't want that. We want just somebody to do what we tell you to do. And it's like, well, you know, some of those chiefs leave on their own because, look, you know, I'm not gonna put my reputation on the line because I know there's some issues in this town and they're not letting me fix it. I'm just gonna end up being part of the problem. I don't want that. And so they'll leave on their own, or they'll bend, and so then nothing gets fixed. It just continues on and continues on. So those are just the things that I just, you know, for the discussion, wanted to say, you know, on the smaller rural jurisdictions, I think that's where probably some of the you know, the talking points probably came from examples that came from these smaller rural jurisdictions. And so those in the bigger, you know, more urban, saying, well, what's the issue? We don't have that problem. We don't deal with those situations. We do that investigation every single time. It's gonna, yeah, it's gonna happen in those jurisdictions, but it's not happening. And more than likely, you guys, I'm sure, vet the people that come into your departments well enough that you're not bringing in these individuals that maybe have that history. But the smaller jurisdictions get desperate and they start bringing these people in, and we don't really know anything about their background. We'll just have suspicions, but we have nothing to base it on. So that's just my...
Oh, I don't disagree with you. I think, you know, is there a way, I think the larger question is there a way to capture, obviously, we have a lot of rural agencies, and we have a lot of large agencies, and it's not a one-size-fits-all, which is the problem every session. Is there a way to basically have some compliance mechanism without making every agency report every single violation of misconduct with that definition to TCOL every time? You know, a case by case, because I guess the whole body has to decide, should TCOL be the police of all of our chiefs and sheriffs, or not, in this regard? Because right now they're not, but this would allow that. This would open that door. And, you know, I'm sure everyone has their own opinion on that. I don't know what everyone's opinion is, but that's ultimately what this does.
Well, and kind of to build on what he was saying a minute ago, some of the things we see in field services, again, a lot of times it's going to be smaller agencies, is when a chief administrator leaves, a constable loses an election, there becomes a destruction. I mean, it's a scorched earth policy. And so the next chief administrator comes into literally zero files. The agency has no documentation over time. And sometimes, you know, you get an opportunity to look into it. What happens is that chief administrator leaves, the minions are left with the keys, and they scrub the files. And so in this notion that things would only be reported to us at separation in these cases, because what the field service agents do when we get a new chief administrator, whether it's an elected official or whether it's an appointed official, is we try and get there early to help them set up, help them to understand their responsibilities as a chief administrator. And a lot of times they're standing there with their hands up going, I have nothing. They have to, even to the point of rebuilding the TCOL required files, which is only 5 or 6 documents and has nothing to do with this. And so I agree with narrowing what gets reported to us, but I think there needs to be some interim in-service, while that officer is appointed, reporting of some of these things. Because at the end of the day, the summary report given to us may be the only documentation left. When that small agency implodes or somebody gets into their files, we may hold the only thing applicant and try and explain this thing away, knowing that they're the last man standing, or last gal standing. You know, that's, I think that there's a case for some interim reporting and not only at the separation. And most hiring, I'm gonna apply for another job before I leave the one I'm in. You know, so if we're separation plus 30 days, or separation plus 75 days, if that's what the model policy ends up being. I think narrowing the scope, as the chief said, of what falls under the misconduct is certainly a noble thing. I don't care if they were late 3 weeks, you know, every Monday.
I'm just trying to cut through this, but what if may suspend means? The violation of law enforcement agent policy that's sustained, and the officer is suspended, demoted, or terminated, and the matter is not under appeal.
But that's the different issue. They're two distinct issues here. Your issue is very valid, but I want to go to your 2 points and his point before we go there. So let's stick on the
This is
one
what
point
makes it
first.
reportable. This is
Reporting is a different standard. The
Yeah.
may suspend just triggers the investigation.
Right.
There's a different standard for reporting.
Because we're gonna investigate everything, but I don't have the volume to report everything to people.
Well-
I hear what you're saying for smaller agencies who may need some of that, those guardrails, and I hear you, but the
No.
you,
misconduct is a definition here. And what requires the investigation is a misconduct. When you find misconduct here to mean what we're suggesting, what I said a little while ago maybe, or any form of that narrows that down.
but I don't care if I have to report it during or after, that's the distinction for me, because we're gonna be investigating all of those stuff.
Yeah, but reporting would be only, again, only where you actually found true. You suspended, demoted, or terminated the officer, and the matter is not under review.
Okay, but we suspend people for 1 day, and that's different from indefinite suspension. So, I mean, where do
If
we
you
draw the line?
if you wanna say suspend for more than 3 days or indefinite suspend, that's fine with me. I'm just saying,
If the standpoint, the crux is when the reporting happens, because we are going to do the investigation no matter what every time. But I don't have the volume or the capacity to give every single investigation to TCOL, every year, every time it happens within 30 days. But I'm happy to when the person resigns or retires, because then it's relevant for the hiring agency.
but you're required to report what constitutes misconduct. If we narrow what that means, then you're only reporting what it
When,
means.
You're not required yet.
right, when you're required to.
And I think that's up for discussion. I think you all said your interpretation was not greater than 30 days after separation. If you all don't go with that, that's fine. But
Well,
I don't read it like that here, but that's fine. I mean, that's not the way I read.
So I think, like Stan was saying, there are two separate issues, and we can't do one without the other. So, and I hear what TJ was saying, that it's easier to start at the back end and work forward, because I hear what you're saying about some agencies need kind of a better understanding of when to investigate and being able to report when that's not happening. I lost my train of thought.
Well, so I think Colin has a very compelling point. Most officers don't leave until they already have the next job in the back. This doesn't help us if we're doing the reporting post-separation. So let's go to each person in this room. Your voices are important. As it relates, don't worry about May, what do we invest in? Don't worry about anything. When are we reporting to TCOL? What is your professional opinion as to when? When should it be reported to TCOL?
So for my agency, I can do at the conclusion of each investigation, something that's assigned. Houston PD and Dallas PD can't do that. So for an agency that is 30 to 50 to 70 folks, we could probably do it every single time. And it wouldn't impact because it would culminate at the end of the investigation and possible procedure standards would
be a problem with the sheer numbers that we have. However, looking at it from the recruiting point of view, and knowing that I need to see that file, I need to see that information, at the end of separation is just not gonna work, because I could potentially have somebody sitting inside the class at that point.
Wanted at the conclusion of the investigation, or within a period of time.
So Lieutenant Clifford said, for Tomball, it's not a problem to do it immediately upon request, but I could see it being problematic for smaller agencies waiting after separation.
So which one are you favoring?
Well, I favor the interim, actually. The interim reporting as
As it occurs, at the
Yes.
conclusion.
I'm good with that to conclusion. Otherwise, you're kind of, you know, I understand the logistical problem, but I mean, you need to know now, and you need to know now.
I would say upon separation.
And logistically, if we're talking about egregious violations that are sustained after the investigation's conducted, I think that would be fine. But if we're talking about reporting everything, even things that aren't sustained or, you know, maybe lesser violations, it would be very problematic to report it continuously.
The law requires us to complete the administrative investigation and submit a summary report in a timely manner, not later than 30th day after separation. You are two persons that were involved in the policy development, and if your understanding is that we were supposed to make it accessible upon separation, I'm okay with it. It's a real stretch of timeliness, but I'm okay with it.
Okay. Yes.
We're a mid-sized agency, and I was thinking exactly what Colin was saying, that everybody I get is employed with somebody else. So if I'm not getting it from the personnel file, which you said if we do our job right there, we're gonna get it. But I think it makes most sense that, and I know it would kill the Houstons and Austins and Dallases, I'm sure, but it makes the most sense to me that if it's something outrageous, it needs to be put in right then. So not at separation, hopefully at the termination of that administrative investigation.
Separation, but if we go with separation, change the 45 days, okay, to 90, all right? Because I'll be honest with you, we pulled recruits out of our academy because we found something. We already did all their background, right? We did our due diligence, all this, something reared its head. They're sitting in the academy, you're out, all right? So if you need more time, then give more time, but no, separation.
You are charged with creating a model policy that establishes a provisional hiring period of at least 45 days, so that can be incorporated into your policy.
Yeah, so to that point, and I think to Colin's point too, the law does have a provisional hiring period for those very cases where somebody is being hired away from another agency. How about a population bracket? This does not apply to agencies above a certain. Because if the problems are with the 5 to 10 people, and we've established that there's no cookie cutter, we can't, I mean, let's solve the actual problems, right? I mean, let's not just find one solution that kind of fixes some stuff for some people, but is horrible for others. If there's a way to.
And for smaller agencies trying to hire somebody from Houston PD, we need to know what's going on then.
And you will, because we're doing the investigation and we're uploading it as soon as they separate or whatever. And, or maybe another solution is within every 5 years of employment, we're giving you guys information or something, some kind of stopgap. But there's no way that Houston, I think, can comply with our current staffing and our current technological capabilities of uploading every single investigation every time.
But you're only uploading the summary document.
Still, that's a lot.
Chief, I think you said it right. It's right after the 45 days, it's the next 45 days. It says take into account the variation in the size,
Correct.
function, and jurisdiction of law enforcement.
That's
law
right.
enforcement agencies of the state. So it says that exact thing that we can
You
look
bracket
at
it and tailor it however you need.
to address the different areas in the state.
And here's one thing about bigger departments, they'll have a more developed civil service file. If we're talking about breadth of information, which the whole, do the investigation into alleged misconduct, again, going back to the discussion of what exactly goes in there, you're gonna have a more developed civil service file, using City of Houston as an example, than you will a smaller department. So, you know, that's something to take in consideration there. If we're talking about what information is available, what information has been developed, it's just something to consider.
Yeah, and I recognize that it doesn't make it clean and easy, but at the end of the day, if we're looking for a solution to address the actual problem, that might be the best way to go. I'm not trying to be difficult, we always get accused of that because we're so big, but just trying to.
Well, I mean, I love the idea. You do have the population bracket and then give us some additional language, and so, good.
When you refer to the actual problem, what is the actual problem?
The actual problem is agencies are trying to hire people and they're not getting the information they need about their disciplinary history to make an educated hiring decision.
But not that the agencies may be not investigating allegations.
I was not aware of that issue because I live in the Houston bubble, but I hear that that is a problem, but that's not the one that I was looking to address. But if that is one that the committee does think needs work, then fine with that.
I don't know that it is. That was my question. That's why I wanted to make sure, because I'm not sure we're all talking about the same actual problem, because I hear different people referring to different things.
Okay. Let's real quick decide what time do we want to end today's meeting. I heard 3 o'clock because some of you have to travel back home. What is the consensus of the group? 3, 4, what do you want? I don't care.
I'm gonna leave about 3, so.
3 is the consensus? All right. We still have 2 revisions that we need to review. I don't even want to circle back to this one because it's just going to lead to more conversation. Let's at least expose ourselves to the other 2 issues, and that way we can break the day. We'll finish the day by deciding when's our next meeting. All right, sir. Let's talk about hiring.
Say again?
Hiring, and then we need to get into personnel files.
Gotcha. Hiring, again, everything's going to come in from taking a look inside the confidential database. You'll look at section 451, which if you have your full book, it'll have the rundown in there of the exact steps that the chief administrator must take to hire. Take a look at the hiring database under 168, like we've talked about. We've also had the designated decertification database. I believe, Cullen, why don't you give us a little bit of background on that?
The statute requires us to identify a national database as best we can to primarily dealing with out-of-state applicants, but the language is all, so all of your hires are going to be bounced off what they call the NDI, the National Decertification Index, which is monitored by IADLES, International Association of Directors of Law Enforcement Standards and Training, through a DOJ grant. The NDI, we just sent out a statewide notice to chief administrators of the need to get into the NDI or have your staff. It's no cost to the agency. You can have basically as many accounts as you need. So if you have 10 people doing backgrounds, and they're going to check people through the decertification index. It is not comprehensive. Not all states do it, but it's the best there is now. I happen to be the approver, so if one of your employees gets in the NDI and requested, what we're going to do is make sure that they're appointed on your roster in TCLEDs, that they have a PID and we recognize them attached to your agency, because it is a went into effect September 1. So we're trying to get ahead of that. We've got a tab, a technical assistance bulletin that we'll be publishing post-case. But that section of the statute actually went in September.
That system is just a pointer system. It doesn't prohibit you from hiring somebody who appears in there, in part because it doesn't have specific, it's not done by prints or by specific numbers. There could be someone with a similar name that shows as a hit. It's just to direct you to someone that you would follow up to find out if they've worked in that state, if they've been decertified, what the status was. So it's just meant to be a tool to help background investigators find possible leads, but it is not it doesn't eliminate them just because they do that.
And we hold none of those records, so you have to contact the listing state. So if Georgia puts somebody in it, you've got to contact the post in Georgia to understand why that person was put in. One, identify that it is in fact the person you're trying to hire, because there are some false positives because it's a name-based system. But that's
Has TICO already submitted all the officers' names into this database?
We have been for some time. Whenever we go through, we have a commission meeting and commissioners approve revocations or cancellations, those get submitted to the,
So
and
only,
surrenders, yes, thank you.
so only those names get
Yes.
submitted?
yes.
Okay, so someone in Georgia doesn't go to this database just to see if I'm in Kaufman, Texas?
No.
It's not going to show that.
No,
It's just, okay.
decertification only,
Yeah.
yep.
And there's no real identifiers in it. So if you got in there and did John Jones, you're going to come up with Penn State.
It's not a perfect system, as Colin was saying, but this was something that Senator Johnson was pretty specific on. Here we are.
Will the BCF be updated to say that you performed that step, or how will there be confirmation of that?
We're discussing that.
Well, the other, so we've been drafting the way that hiring module is what we've been calling it with us, and that's the other document that we have along with the misconduct report. But yes, there would be a step included in the checklist to check into that. And we would link you over to it.
Technically, right now, the bottom BCF, the chief administrator certified that all requirements except for 451 have been met. So it's not a specific line on there, but it is referenced as you can see.
So that's not just negative people, for lack of better words, in that system. It's anybody who, like in Texas, would have separated, like if I separated today, my name would end up in there.
No, the only people Texas reports into that system have had their license revoked or canceled, which means they shouldn't have had a license in the first place, and so we negate the license.
Or you surrender
Yeah,
as part of a
or,
criminal
yeah, terminal
resolution.
If you look at section, I'll give the sites for the basic background investigation process. 1701-303, which is an SB 1444. Like I said earlier, this is kind of a little bit of a puzzle. That's how we got here. 303 says review any information, a law enforcement agency or governmental entity before they hire a person for whom a license is sought. The agency or entity must review the information available in the confidential database, in the publicly available database, and the information that we just discussed, and not much changes as it's been in the past to that. Let me move to the requirements under 451 here. 1701-451. Go here. And this goes back to our earlier discussion. 451, you'll get the person's written consent as it is now, along with the things that are currently required in the background process. You'll have the personnel files as described by section 1701-4535, which were the personnel records, that we've been discussing here, along with the report submitted to TCOL in 168. You'll also have the misconduct investigation reports in there, like we discussed.
Any information of the person's law enforcement background is available through the database designated by the Commission under 169, as we just discussed. And along with the current components, that's your background and investigation under 451. Any thoughts or questions from staff or anyone on the committee?
There is none.
Nothing? All right, well, we'll reserve the rest of the time to discuss the personnel file. Surely that will be contentious.
Personnel files, we put local government code 143089 up here to compare it with 4535 because they're almost identical as we discussed earlier, and we may be just better served clicking back here and going through it like this. Again, a quick comparison before the civil service file and the 4535 file, personnel files. The civil service shall, here the agency is required. The agency required. So if you're civil service, there's not much that's going to look too differently on your side as to what's in that personnel file. And when I say personnel file, going back again, that's the A through F file, everything that's subject to disclosure, not the confidential G file. So 4535, you'll see some differences. Civil service, no changes to your world. But everyone else, you have to establish, and it mirrors exactly, let's not say exactly, there are some changes. As we go through here, misconduct documents from the employing department, agency, obviously using the language in the 4535 file. That resulted in disciplinary action, as we were discussing earlier. Periodic evaluations. Going back again to what can be placed in the personnel file and the G file or the 4522 file. Document relating to alleged misconduct may not be placed in the personnel file if there's insufficient evidence to sustain charge, Just like we said here, is the allegation sustained? Yes. Personnel file? No. G file or other?
John, I was struggling with this one, and I reached out to Stan too.
Sure.
So do I understand it correctly? Basically, my personnel file that I have at home, in our office, and basically I'm going to put one in this confidential system, database system, and there'll be basically mirrored personnel files. That TICO's going to have one on, and we're going to have one at all times.
No, I wouldn't say at all times. I say 30 days after separation, and I believe that is the language. At some point after separation, into that confidential database is where that entire personnel file goes. Does that make sense? And that was the kind of discussion.
Your personnel file, then you send a copy to TICO.
Yes.
So you're not going to have it while they're employed with us?
Correct.
Okay.
Unless
I was
yes.
thinking by you were going to have one at all times. You're only going to have it when we separate.
That's correct. That goes back to supporting the idea of having a global unqualified universe of information that the hiring agency, the prospective hiring agency can look at. But TICO will not need that in the confidential database until separation of the licensee.
So if you're hiring somebody else that's currently employed, they're still going to have to do the secure share part, contacting an agency.
Correct.
Because they're still employed somewhere.
That's correct.
And
That's
is
correct.
that personnel file upon separation, is it A and G?
Yes, everything goes. Everything goes, yes. Because as it goes, think about how it is now. G file now, under civil service, again, using that comes to secure share now. Gets the agency reviewing those documents gets the entire 143089 file.
Okay.
And remember, again, to the world, it's confidential, the G file, but to the prospective hiring agency, it's wide open if it's in the confidential database.
Got it.
Any questions? Those are good questions and comments. Any further on that? Okay.
And here I thought this is an interesting difference. Maybe you guys could give us some insight there in on the discussions on this. Civil service side, you give the notice to the officer within 30 days of the inclusion of a negative document in the personnel file. Same for 4535, but here, on the 4535 side, if you're not civil service, they've got 30 days to respond to that notice, but on the civil service side, 15. I thought that was interesting and worthy of note. Officers entitled to a copy of any document in their personnel file. Can't charge them.
Go back up there? 'Cause
Sure.
To me, that's not a crossover.
Where
I was just learning from some of you all that you already do this, but for us, we do not send by certified mail every time we put anything in a personnel file that may be of an adversarial manner. To us, that's a game changer. That's postage, that's time, and we do everything in an electronic repository. Everything is electronically done. So when I enter into this electronic repository, the employee is simultaneously notified of every entry to include the exact content of the entry. And now the legislature is going to say, oh, but by the way, we also want you to go out and do certified mail every time you do something negative. Is that how we're interpreting this?
Well, I don't know if I said certified mail, I didn't mean to.
It says in here, LEA shall notify the licensee by certified mail.
Tell me what we're looking at,
I'm
Stan.
looking at this document that I think Gretchen did.
That's what the statute says.
That's what the statute says.
The issue was, someone will leave either voluntarily or involuntarily, and then after they're already gone, within, a week or two, they'll put a whole bunch of discipline in them, and the employee won't even know that it's there. So that's what this is trying to address. The employee being advised that something was put in the file.
Demonstrated notice.
Correct.
So you're late, I write you up, second, third time, we're sending you certified mail.
I'm gonna have to read the statute.
Is there a provision you can do in person? I didn't read that. I thought it was pretty clear.
And this is just in general. Notice, in-person notice is the best notice there is.
You would think so, but I don't think it gave us an out.
So 143.089D does not specify who is certified mail.
It says in here, the license holder may, or if a negative letter, memorandum, document, or other notation of negative impact is included in the license holder's personnel file, the agency's head or the designee shall, not later than the 30th day after the date of the inclusion, notify the affected license holder by certified mail. What in the hell did we just agree to? Was that the labor?
Well, we certainly didn't say no to it.
I mean, think about it. I'm going to say, hey, you're late, and I'm going to put it in an agency 360 entry. It's a negative entry. Now I'm going to do a certified alert.
Well, I need to go back and reread the statute. Are we talking about the permanent personnel file? Or are we talking about a small local file? Because like in my department, there's like a sergeant's file where, hey, I told you to shine your shoes, write a little note, it goes in the file. That doesn't go in your permanent personnel file. So I just need to read the statute and talk about which file are we talking about.
We have only permanent.
But that,
personnel
exactly, and this is a
files.
huge topic right here, is
What
the different
that's
files
mentioned.
and what you can and can't keep, which should be, I think, talked about in this personnel file discussion. Because it's going to become a big deal, especially in 143 cities, where they're now saying, under these activist, ordinances that they're passing, that the city doesn't have to keep a file at all. That's what they're alleging, is that a G file. So they're basically saying, well, it says we may keep a G file. City of Austin and the council is saying, we're not gonna keep a G file. So in other words, everything is releasable. So what's allowed and what should we talk about when we're talking about the personnel files?
And we had this conversation earlier, and I think my opinion, this is my opinion, is that if you don't have, it's no different than if you saying, okay, everything that I think should be in the personnel file, I'm going to put in the G file, but since it's in the G file, it's non-disclosable. You can't do that. But you, by the same token, on the same, that's the same principle, you can't say, I don't think, well, we don't have a G file, so it's just the same as what you can, it's subject to release. In other words, the absence of a physical G file, in my opinion, does not necessarily mean that it has to be released. If it meets, one can argue, if it meets the definition of 143.089A and everything, I think it's pretty clear what a quote-unquote personnel file is. Anything outside of that, unsustained, things of that nature, everything that does not fit the definition of a quote-unquote personnel file, technically falls into a other or G file status. Does that make sense?
That's what.
Would that G file then trigger that certified mail? Or does just the A file trigger certified mail?
Let's take a look at it. I will tell you this. I'm of the opinion that as a committee, okay, certified mail is certainly constructive notice of, if you send something to someone via email and they respond to it, they've gotten notice. You don't have to send it to them certified mail. Certified mail is important as if they're gone, they've separated, things of that nature, then that would be a good idea to do that because you have a record of sending them the notice of the violation. Always think of it like this though. Certified mail is substitute notice, and if you hand somebody something, it's like an F5, by hand delivery, and you mark it on there and you hand it to them, that's the best kind of service there is. So I'll leave you with the thought that there may be some discretion for you all to incorporate personal or more direct service other than certified mail. It's just a thought.
So in person or certified mail?
I think in person is the best.
Even though the law does say certified mail.
It's allowing you to send it via certified mail because personal service face to face and them signing for it right there.
It's giving you a lesser standard.
Exactly.
It's the minimum standard. But
Exactly.
That way.
Exactly.
And we're also adopting a model policy per the statute. which
That's
is
right.
Where we can
That's right.
integrate that language.
Absolutely.
Okay, I suddenly like some labor again.
I wouldn't send it via regular mail, let's put it that way, but you
All right.
can hand
I can
deliver.
live with that. I have no issues because I agree with what you said. That's regrettable. All right, thank you.
Chief, I want to point out, this is where I kept referring to the wording difference where it says that the misconduct resulted in disciplinary action by the agency, that the may is gone, now we're talking about disciplinary action, and I don't think disciplinary action is defined. For example, I think we traditionally, oral reprimands and written reprimands were not disciplinary action because there was no ability to appeal those, but days off or something that is subject to appeal is considered disciplinary action. And I think that's where you would, I think some of the concerns that you had, Chief, are actually going to fall under this section and could be defined here more easily than the trigger to what requires an investigation, which I think is a separate matter.
So, yeah, the one issue I think that we need to address going forward is, in a civil service setting, you've got the civil service director as a custodian of the file for the most part. In some cases, you get collective bargaining agreements that specifically specify that. So that's one side issue that needs to be addressed. As it relates to whether or not you provide notice or certified mail or whatever, in a 143 city, the law specifically outlines what you can put in a personnel file. And there is some AG opinions that concur with that, as opposed to, I try to put, you were late yesterday, I'm going to put it in your file, AG's come back and said, that's not placeable in the 143A file. So what I'm saying to you is that you can have those in the G file and not necessarily be regulated by the certified mail records that we're speaking about. That's what I'm trying to address.
But those would not come to TCOL on conclusion and be included in the 4535 file, right? That's our understanding.
Say that one more time, TJ.
If he wants to keep something in a G file that says they were late with their disciplinary action, that's not something that would later on separation come to us and go into their personnel file, because that is not something that resulted in disciplinary action.
It would not go in the personnel file, but it would come to us under subsection H of 143, which allows that to go into the confidential database for review.
That's why I asked earlier, he gets A and G. He gets
Yes, everything.
So you were saying, John, on the personnel file, when it goes to the confidential database upon separation,
Yeah.
how long is that there and what is it there for?
It's for hiring purposes.
Okay,
And then for how long it's there,
but I thought that's what TSS was for. Is it separate because of what's in there?
it's separate because it came before this. With the additional resources we have, and I'll turn it over to Jessica, we had this discussion on how we're going to kind of
Integrate
transition
that?
this.
Okay,
Yeah.
got it, that's what I was confused
Yeah.
about. Okay.
Jessica, do you have anything to add to that? I know
Yeah,
it's-
what our concept is taking TSS, basically rebuilding TSS and integrating it with TPLEX so that, well, one aspect of it is we can intake records of misconduct, however they are defined, throughout the process. We can categorize them properly. And then we build this hiring module that incorporates the background confirmation, the request of the background documents, and the L1 and the F5 all in one hiring component.
And is it codified somewhere that that is not, or I guess you were saying you would argue this section here if it was to ever be requested on a PIR?
Yes, you talk about everything, right? Obviously the G file, we know it's got,
Yeah, the database, the confidential database.
absolutely,
Okay.
yes. That's a slam dunk.
It's in the name, right, John?
That's in the name. It says it on the tin.
And that goes back to earlier where we said if somebody's going to get the personnel file, it's going to have to be from the agency, not.
But even then, I think we defer to what we were discussing earlier, designated for submission to the TCO confidential database. And then we go from there. Because we don't have an express confidentiality provision for non-civil service, non-personnel file information at the agency level.
And that's, I mean, I guess the AG's that hasn't been disputed, that this would be.
It's wide open at this point. But that, again, I go back to, we do the side by side and there's no corresponding subsection G to 4535. It's expressly confidential, but I think there's a very strong argument to be made that corresponding information, if it were in a civil service file, would be confidential, and that same information is destined for a confidential spot later, and the overall purpose of that provision in that type of file is for protection of the officer's privacy interest. So I think there's a very strong argument that can be made that it is confidential, even there is not, at this point, an express confidentiality provision in the statute.
All right, keep going on the personal file.
All right. What we were just talking about, civil service director can't release the information in the personnel file without written permission unless release is required by law. Case law and otherwise indicates that everything in the quote-unquote personnel file is subject to disclosure, if not in the G file is not. Same situation for the 4535 file. With the officer's permission when they're going to a new agency, the written consent form to allow for the release of all information pertaining to them from the previous employers. Again, as we noted, the department maintained a personnel file on an officer employed by the department. The departmental or G file
Civil service has it. We don't have that same provision here, for the reasons we discussed. Department may not release the G file. Any agency or person shall refer the requester to the director or designee. However, here's the carve out for TCO purposes, and this goes back to last session. I don't think this was an SB 24, but it was related. It was SB 24. It was included in there. As provided 1701-451, which pertains to background procedures. Hiring agency is entitled to view the contents of the personnel file maintained under subsection G. So obviously, along with the disclosable file, prospective employers get to see everything. On the 4535 side, got the same thing here, unless it's required by law. Again, same language, 1701-451, agency hiring officer is entitled to view the contents of the personnel file. Any thoughts or questions there? And here, the new law, 4535, agency shall provide personnel file to TCO not later than the 30th day after separation or on request of TCO as part of an ongoing investigation. Any thoughts, questions, or comments?
So I'm not as familiar with civil service as probably most in this room, since I don't work for the civil service department, but is there a definition of personnel file somewhere in statute?
There is. Refer to 143089, and I always look at it as it's defined by what must be contained within the quote-unquote personnel file. And it gets a little confusing because you'll see through the section personnel file used in several places. The courts have kind of separated in the 143089A, they call that the personnel file. They'll just call that the personnel file for shorthand. And the G file, or they'll call it the civil service or the personnel file, but for our purposes we call it the personnel file. The G file, is the department file. And that's the way they'll distinguish the two. So you're not saying personnel file and referring to the A file versus the G file throughout.
But what about the non-143 cities?
That's where 4535 comes in, and I think, again, we mirror the personnel file. I think that's mirrored just like it is civil service. But the only difference is you don't have that specific G provision. But for all the reasons we talked about, I believe it's just as protected.
In one version of the bill, we said personnel file has to be from 143, but then they changed it to listed out.
Yeah.
And it pretty much is. I mean,
It mirrors it, yeah.
So that actually results my tension about anything negative, like a negative memo, because none of that would ever go into an A file anyways.
Yeah,
That would always go G.
the only thing that would be nice is if in here we could, I don't think we're gonna be able to, but if we could, codify that you cannot release material in the IA files. If we could codify that in here, that would give it the full 143 protection.
But if it's an IA and it's sustained, it's fully sustained.
No, the unsustained.
Oh, yeah.
Unsustained, but right now it says unless required by law to release in this one that we did. If we didn't have that, or we had a way to say, into IA files, or to codify that they can't release the unsustained information regardless of
We're talking about
what they fall under.
non-civil service, unsustained allegations.
Yes.
That's
Yeah, if we were able to somehow rope that bottom one into the O9G via this, I just don't think.
Again, I think that's where we say this is analogous to a G file information. Where it's at and where it's going is confidential. As a result, it should be confidential in the hands of the department. I think that's kind of the best argument there is for making that confidential. Or it's an argument. There may be better ones.
So how does my department fall under that then, since I'm not under any of that? I'm chapter 147,
I would say, this is my initial response to that. I think the overall legislative imperative is, if you're not civil service, you're this.
But I am civil
They are.
service.
Yeah, to what extent,
Civil, so-
that's a great, okay, then I would like to see what y'all's statute is in comparison to that, to the 143, in comparison to 4535.
If there's conflict, right? That's the
Yeah.
question, is whether or not there's some checks. and
Yeah.
balances that conflict. They just used 143 as the outline.
Right.
They previously defined personnel files, so we were using 143 as a loose definition up to this point anyway. When agencies called us and said, what should be in a personnel file, we directed them to that to use as an
I
outline.
think we probably are.
Yeah, it probably is.
I'm sure we,
This is in the absence of, if you have nothing there.
Yeah.
County agencies,
Yeah.
non-civil service, unless there's another applicable provision, set of provisions.
But the meet and confer contract should supersede.
and that's my,
So if
that
there's
was my
something
question, I was
specific.
gonna ask you that. Our contract would supersede this.
But there's probably nothing in your contract on this particular.
There's
issue.
nothing in chapter 147 that says it's just a bracketed bill, and it gives us full autonomy.
Yeah.
I mean, because it specifically says a city over a million that hasn't adopted chapter 143, 174. We kind of are,
Depending on what it said, to see it, yeah. Because it's,
But I know we're following, I know we.
no, it's gonna come up out there though, and the question is, I mean, what controls, new misconduct procedures by the legislature or existing, can you negotiate out of this? I don't know. It's like
Typically, yes, is the answer. I mean, it's not to
supersedes
say that yes.
statute, yeah.
Yes, the
I can see
contract
that.
would, but again, in this world, it's a changing scenario.
Are you saying the statute would
No,
supersede?
the meet and confer contract.
Yeah.
So are we gonna get someone to get an opinion on this in terms of 174 and its applicability, maybe 147?
Say the first part of that, Chief.
Are we gonna get somebody to get an opinion on this as to whether or not 174 is gonna trump all of this for 174 cities?
Sure, I think the best thing to do is, my first inclination is get a hold of some of the 174 cities folks and chiefs and whoever, the legal advisors, get them together and say, do y'all have some previous determinations, some previous opinions, something that we can use to kind of guide us? Because I know the question has come up before, obviously not in this context, but maybe another context. I used to come up with, does statute trump collective bargaining, so on and so forth. But no, I think that's something we've got to run down for sure.
Well, and so, to me, that is the heart of this issue. If you don't know, there will be a petition filed this month in San Marcos to repeal civil service. We believe that the meet and confer agreement, as afforded in 142, says that you are allowed through meet and confer to meet and confer on hiring, firing, working conditions. Those three specific things are mentioned in statute. A lot of what we're dealing with is occupations code that's outside of 142 and 143. So does meet and confer supersede on 1701?
Well, and that's the thing is there, we would have to identify the actual conflict, I think. first.
Exactly,
I mean,
exactly.
otherwise we're just talking in circles.
I'll give you a specific one.
Yeah.
They want to say that these officers can no longer look at their body-worn cameras prior to providing a statement. That's
Who's they?
afforded in 1701,
Who's they?
the group that is going after civil service. So I have said, wait a minute, the agreement cannot contemplate that issue. It's not hiring, it's not firing, it's not a working condition. It's a policy codified by the legislature in 1701. Completely outside the scope of 142 and 143.
So then it wouldn't be in your contract at all. It wouldn't be addressed in the contract.
Bingo. That's
So then
what
it would
I,
just be stated.
they want it to be. And I've said you can't.
Yeah.
So I agree with your question, Victor, that we do need some legal advice on this. Now, follow-up question. Has Austin already adopted this mindset of we don't have G-file anymore?
So they, I know I'm being recorded, but, so they filed for a request for a ruling, and in the request for the ruling from the AGs, they stated that they no longer maintain a G file because they adopted an ordinance that was enacted, similar to what's going on in San Marcos, they adopted an ordinance that stated they could no longer maintain that file. For obvious reasons, so that everything would just be releasable. Well, the AG ruling was basically said, oh, you don't keep a G file, then none of this pertains to you. So we've asked for a clarification while working with them, and we can happily release that once we get their ruling, if we get that anytime soon. Because they do keep a G file. You can call them today, the department, not the city council, but call the department, yes, they keep a G file today as it stands.
So
And
can
always will, more than
Can an
likely.
ordinance then supersede
That's the question,
14309?
that was the question that we are requesting an opinion on. So we're waiting for the answer. Which will be very relevant to your situation.
Hugely relevant. Thank you.
Any other thoughts or comments or questions?
If not, we need to contemplate next meetings, and we need to contemplate how do we get some work product done to bring to this next meeting to move this along, because we have until what, March 1? March 1
Yes, sir.
to promulgate these two model policies.
March 1 is when the commission needs to adopt it, which actually means it would have to go before them at their late February meeting.
Okay, and I asked you all, but can you, for the benefit of the group, what does that look like for presentation? Does staff present those model policies to the commission, or is this committee doing it? What does that look like?
I think, and I don't remember if we talked this specific, but I think the chair or co-chair or in combination or any committee members that wanted to come present with staff the findings and the policy that you want to present to the commission, I think that would be good.
Jessica would love to.
Do you have to post these?
Say again?
Do you have to post these as rules or not?
We will need to post rules, but not necessarily model policies. We'll go into a different section.
So does that move the day forward or not? Because posting for rulemaking.
So, rules get posted once the commission has voted to propose them, and then again, once they vote to it, finally adopt it. But this is a little bit different.
This policy doesn't have to go through the rule-making process.
Okay, so I would suggest, just as to initiate the conversation and moving forward, do we want to contemplate some of us working on May investigate, and what that should be? When do we agree that there should be consensus that this is probably going to be egregious conduct we shall investigate? Do we want some of us working on that, and then some of us working on, to Jessica's point, the population bracket language that would take into the account size, jurisdiction, and function? So we're working on policy language associated with both of those things. What says the group?
I think a lot of it's gonna depend on what we hear back from the AG.
We're
That
not
could
on top of
take,
it.
yeah, that could take
Yeah,
a while.
especially with everything going on. So, do y'all want to work on?
Can I ask,
Yes, sir.
when you're talking about population, are you talking about population only to the provisional hiring or the entirety of the?
So we're talking about when do you report a completed investigation summary report to TCO? And Jessica's asking for consideration, several of you did actually. Can we take into account the size, jurisdiction, and function of each department?
So
As
it's
to
the
when you report it.
It's the whole thing,
Yes, sir.
the reporting, the investigation, provisional hiring, all that kind of stuff. You're trying about breaking that up into population sizes, or at least carving out some populations, more or less, or something like that?
We have bracketed in such a way that you have larger departments, we'll pick a number. I mean, it's not difficult. We'll just, I understand you look at sheriff's departments, stuff like that, and that size, and maybe you can designate whether or not the sheriffs versus municipalities, but
I have one size, 150,000 to 200,000, never.
but it's easy for
Well,
us.
it's got jurisdiction as well, so I
Yeah,
think we could look at
okay.
population jurisdiction. I think there's several things that we could break it up in.
I don't think it'd be real difficult to.
Okay, I was just wondering if you were doing it just for the original. I heard that discussion when somebody mentioned the 45 days thing, and then it came up, said, well, what if you have a small little RV, that kind of thing, that's what I was asking.
Well,
I
this
understand.
makes it all, I mean, when we get that, the smaller agencies need this in that regards to, which I'm fully.
I just want to understand.
Another way to look at it could be, and I think you stated this too with your area, was if you're covered by 143, you wouldn't have to. Because clearly, those agencies are in compliance. Maybe not, but I think they're probably in compliance, and then the ones who are at will would be required to do some kind of reporting, intermittent.
And we're referring to the reports.
Yes.
Reports.
When to,
Gotcha.
so why don't we have the 3 J's do that?
Who's the third? James?
Three. Why don't we have you all come back with sample language for our next meeting as it relates to use your phrase, population bracket? And it would contemplate size, jurisdiction, function. Okay, who wants to work on may investigate? What you would consider, to Victor's point, what is egregious conduct? What would normally trigger suspension, demotion, or termination? Who wants to work on that sample language? To me, that wants to be simple. 1, 2, I'll come back on that one too. 3. Why don't you jump in on there? 4. Okay. Before we talk about next meeting, what else do you feel like we need to more carefully consider today in anticipation of the next meeting? Anybody want to take a stab at the language on the certified mail versus in person? Sounds like an HR function. Would you be willing to do that, Christy? Sure. Okay, so I agree with John's point. In person is always best. So in person, in lieu of, or you can contemplate several options there.
Is it our responsibility to decide how long TICO's going to keep personnel files that you mentioned a minute ago? Is that part of our scope?
I think,
That's the answer, you said 10 years.
At least 10 years.
yeah, that's going to be a state records retention, those will be applicable, so I don't think that's necessarily something, it'll be longer versus shorter for sure, but something we can think about. But I think we can default to the state retention schedule. 10 years, Aaron, at least?
It's 10 years in statute, at least. It can be longer.
Are y'all keeping them longer?
Well, we
This is
don't,
new territory.
we don't keep these documents currently, but I think officer records.
This right there is going to be longer than 10 years.
Yeah.
Promise you that.
Part of our records retention schedule says that officer files are permanent.
Yeah, it's something like 75 years after death or something.
But again, if you go back to look at the intent of all this, is to allow chief administrators to make informed decisions. There are people who can work someplace for 25 years and then go to work somewhere else. And so what we have now is a lot of people are asking for files 10, 12, 15 years old and nothing is available. And then ideally those would continue to be available. So I think it's feasible to expect they would exceed 10 years for the purpose that they're intending to serve.
I think that's, one thing, not to start an argument, but one thing that recently happened was, there was some old record that was found somehow, I don't know how, of an APD officer who he was hired and maybe shouldn't have been because of some very old conviction that he had. And again, I think that's the fear. I don't know exactly all the details of how it played out, but the fear is that, if TCOL's collecting all of this information and then 10 years later, because this officer was in good standing at APD and had been an officer for years with no, major incidents. That's kind of that's the fear that's a group like us would have is, well, how did that happen? Like, they're dating back 10 years into someone's file and all of a sudden they're going to take his license away, which is what ultimately was going to happen. We intervened and we were able to work something out and the commissioners agreed. But that was a process that had to occur. And so so why did that happen? And that is kind of a fear that we would have about this retention of records for X amount of time and what's being done with them. Because I agree, if the spirit, like we were told, is just for prospective agencies, that's one thing that we don't disagree with. But there's, you know, are there any other, and we know that there are some other, because now we're being told that you're gonna look at, you know, compliance by heads of agencies on investigations, and so there's just more to it that I think we should all think about before we come back and discuss this again.
And her reference that the world is changing is really important because it is changing. In that particular case, the agency was doing a CJIS compliance thing and ran criminal histories and found something that had been overlooked before. It was all within the agency, the records that existed, and part of another process they were conducting that then they brought it to our attention. And that's the thing is, in the past, something that happened 10 years ago is gone, and no longer is something that happened 10 years ago gone, right? It's now on the internet, it exists in several places, and so that's part of what we're dealing with. We're constantly asked to produce records or uncover things that don't exist in our records, but exist in other places. And so I think that's what everyone's going to have to anticipate is that it's not going to come here and design for a short period of time and be gone, and then that's going to, the question is, can a chief administrator balance that information appropriately? In other words, can I interpret something that happened 15, 20 years ago when information is available to me now and making an appropriate hiring decision whether it's done?
Unrelated, Jessica asked a good question.
Yeah, I was just curious if there's, we didn't have a whole lot of discussion about the model policy regarding hiring a license holder, except to the extent of the index stuff. Do we need somebody working on memorializing that model policy as well, or is it just a question of adding that new stuff in?
So we already do comprehensive background investigations on new hires. Is it as simple as adding the MDI to that checklist to say that's the model policy?
Yeah, I think spelling it out in the policy is a one sentence you go to, and I would use the same broad language that the statute uses. You will go to the TCOL designated database, and that's just one step. So in my mind, you understand it's one sentence in your process part of your policy.
Again, I really encourage you to consider the context of all these other smaller agencies. The number of people that are asked to do background investigations who've never done them, have no guide. I can't tell you how many agencies do zero written documentation of background investigations. I get an F5 where somebody wrote a few notes on it. That's all they have. I can't tell you how many investigators have to explain that you cannot view records in person if you're doing it over the phone. No, but I talked to them in person on the phone. No, in person means that
So
you
there's
look
not
at
an
the file.
existing policy on how to do a background investigation with people?
No, you have the opportunity to write a model policy that those agencies will adopt and will give them a guide for executing 1701 and 451. So I would add some meat to the bones that are here in that give those agencies the opportunity to have some guide to work from. Just saying that you have to do these things is apparently not enough, at least in my experience, and I've seen over and over and over. And those failures are not what I believe are intentional rule violations. I think it's a lack of knowledge, a lack of experience, and a lack of perspective.
So who already has a model policy? Who already has an existing policy on how my agency will conduct a background investigation?
We do. We make Houston does.
Okay, do we want to actually send them to me, and then I can disseminate them to the committee, so we can look at some best practices?
So
Why
also,
reinvent the wheel?
as part of SB 24, there's a statute for some minimum things that have to be done, so that would be easy to incorporate into the model policy.
Okay, perfect. All right, send those to me.
And that's one, if we're going to make like a subgroup on that, I'd really like to be a part of that one, because I've done dozens of background investigations.
Sounds like you want to chair that specific.
If we're doing a subgroup, I'd be happy.
Send them to you, TJ?
Either way.
TJ, last name Spector, will chair this subcommittee. So send them to TJ instead of Stan. Less work for me. Okay?
And you're gonna work with TJ?
I can help in the meetings.
As well? Okay, who's gonna take point on the May language? Sounds like a city manager thing. All right. They investigate. And that was Stan and Jason, right? Jason Warren?
Yeah.
Wasn't there one more? Yeah, I'll drop you if that's okay.
Yes, sir.
Victor, do you want to be on that one? On the May investigate?
Should be whatever you have on it, I'll give you my feedback on it.
Okay, Victor. And then the timeliness, where we have 3 J's. All right. Any other things that we have failed to contemplate before we pick our next meeting date and from staff? What have we missed?
I think you got it all, for now. Yep.
Okay, was this meeting venue good for you all? As good as it gets?
In the central, too.
I hear no complaint. 10 to 3, good. You missed the worst ends of traffic? You're hearing this, aren't you? Okay, next date. Pull out your calendars. Now the bidding shall begin. I'll throw out November 7th. It's a Tuesday. Ah, I will throw out November 9th. It's a Thursday.
I cannot do
November 2nd.
that. I cannot do the
I would prefer not to do Thursday.
Okay, what about
November 6th.
Monday? Okay, November 6th, Monday. What? Is that easy? Going once. Good with staff? We need to make sure y'all are good. No planned holiday on November 6th?
We'll be in training. Y'all got this.
Just you or all the staff? Okay.
We're good.
November 6th, next meeting. I will send out a calendar invite. At T-Pole 10 to 3.
Has TEPL made model policies in the past on other topics, or is this the first time?
Nothing comparable to the scope of this, and certainly not based on this extensive legislation that we have right here. Not on the subject matter for sure.
I was just wondering if there was other examples we could look at to see.
We're kind of starting from scratch on this one.
We're building the whole, that's right.
All right.
I do have something to say. So agendas have to be published in the Texas Register 7 days prior. That puts the deadline to publish the agenda November 30th.
October 3rd.
I'm sorry, October 30th. So my deadline would be that Friday, October 27th. So you'll have about 2 weeks.
Can we give you the agenda now? Because it's going to be a subcommittee report for discussion and action regarding May investigate, what that entails. Then it's going to be a subcommittee report on when to report to TCO investigations. Then it's going to be a subcommittee report on best practices associated with hiring a licensed holder or licensee holder.
Stan will draft it, send it to you for approval, we'll get it posted.
Okay? And then we can just have, what?
Would you repeat the last one, please?
It is the review and take action or discussion on best practice policy associated with hiring a licensed holder.
We're like the mail.
certified mail. So the fourth bullet would be, review, discuss, take action on personnel files as delineated by in-person or certified mail. And then the no actions. There's discussion, typical. All right. Is that it? I'll let Jessica have final words, please.
I don't have any final words. Well, I want to say thanks for being here. I know this is kind of a grind, and we've had a lot of good conversations. It's not going to be super easy, but I'm confident that this group will get there, and I'm grateful that you guys are here for the journey with us. With that, I'm done.
Get out of here.
Just real quick. I know it doesn't look like there are any members of the public, but just in case, ask for public comment. It's an agenda item.
Okay. Is there any public comment from any citizen, in person or virtual? Hearing none, there are no public comments, so we'll close the public session. Thank you. We are adjourned.